Hey, good morning. My name is Parole Officer Wagersman. Today is Monday, June 15th, 2026. And this is a Public Act 23-169 hearing, the Connecticut Board of Pardons and Paroles. For the record, Mr. Jones, the state of Connecticut passed and made effective as of October 1st, 2023, the Public Act 23-169. It's an act concerning parole eligibility for an individual serving a lengthy sentence for a crime committed before the individual reached the age of 21 in criminal history records erasure. You fall under this act, and this means that you are under the age of 21, that the board shall give great weight to diminished culpabilities of juveniles as compared to adults, the hallmark features of youth, and any subsequent growth and maturity that you've displayed while we're reviewing you for suitability today. Following board members are present this morning by stating their names on the record, certifying they reviewed all statutorily required documents in preparation of this hearing.
Good morning, I'm Jennifer Zaccanini.
Good morning, panel member Rodriguez.
Nancy Turner.
Also in attendance this morning, we have Attorney Susan Conway. Attorney Conway, can you please state your name, juris number, and business address for the record?
Samantha Conway, I'm sorry.
Oh, I apologize.
I didn't know if someone else was also Conway. Samantha Conway, Broder Law Firm, 440023.
Thank you very much. And I believe you have a social worker present with you today.
We do, Dr. Jocelyn Hall.
Yes, can you please also identify yourself for the record, please?
Jocelyn Hall, Mitigation Specialist, Waterford, Connecticut.
Thank you very much. I don't believe the state's attorney, Charmise Wolcott, is present at this point in time. She may join at some point during our hearing. Also present this morning, we have Office of Victim Services, Ms. Vasquez, and our board supervising psychologist. Mr. Jones, can you please state your name and inmate number for the record?
Roger Anthony Jones, 243897.
Thank you. This is a public hearing in accordance with Chapter 14, Freedom of Information Act, Connecticut General Statute 1-200, which applies to this procedure. Mr. Jones, if you have any questions concerning the above, please bring your questions to the attention of the panel at this time. Again, this is a public hearing. Mr. Jones, do you have any questions?
Not at this time, no.
Thank you. And are you willing to proceed with the hearing?
Yes.
Thank you. So as previously indicated, this is a Public Act 23-169 hearing. It's being conducted in consideration of the parole application for Roger Jones, inmate number 243897. Mr. Jones is serving a sentence of 108 years flat with no probation to follow for 2 counts of felony murder, burglary in the first degree, conspiracy to commit burglary in the first degree, larceny in the first degree, conspiracy to commit larceny in the first degree, and conspiracy to commit larceny in the second degree. There is victim input in this case today. There is also an offender accountability plan in place, has been reviewed. Shows that he has completed programming such as understanding and reducing anger feelings, Tier 2, anger management, semesters within the Second Chance Education Alliance, Voices, New Thoughts, as well as People Empowering People. He's presently mentoring in a People Empowering People group, and he maintains a job assignment. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score on the RT falls from the low range risk for recidivism. Mr. Jones, this is now your opportunity to express to the board why you believe you should be granted parole, and you may begin.
Give my statement. Can you act like this already if I say their name?
Mr.
You can
Jones,
speak. Go ahead. I'm sorry.
Oh, I didn't know if I was, can I say the names?
The names of the victims. I mean, you don't need to. No, we know who the victims are.
Okay.
And we did receive a letter that you sent us, a statement to the board. Are you reading the same thing?
Yes.
I mean, it's really not necessary. If you want to kind of summarize, I don't want you to take time away from your hearing because we have other hearings today, so that it is time limited. So, and I know it's a very lengthy statement because we did review it. So, you know, get the main points out. Make sure you say what you want to say, but you don't need to read the entire thing. Thank you.
Okay. All right. Before I begin, I just wanted to say real quick. I remember back in 2001 when I got sentenced. The judge essentially gave me a life sentence. Never in a million years did I ever think or dream that I would ever get an opportunity like this. I remember when my counselor called me to her office and said that I had legal mail, and I took the mail to my cell and I opened it and I couldn't believe what it said. I stood in the middle of my cell and tears just started pouring down my eyes. I don't know if I stood there for a minute or for an hour, but it felt like an eternity. Time stood still in that moment and I was overcome with emotions. I said all that to say that I am so humbled and extremely grateful for this opportunity. Before I start, I just want the board to know that I'm super nervous. I could feel my heart beating out my chest. So if you just bear with me as I try to get through this statement. First and foremost, to the family of John and Patricia Hall, I am deeply and unequivocally responsible for the hurt you've endured for the past 29 plus years. I will always regret the pain, the grief, the sadness, and trauma I have caused you all. I know I'll never be able to comprehend the magnitude of suffering you've experienced, but I do know it is immeasurable. I've prayed and I continue to pray daily that God continues to strengthen you. I would also like to apologize for not accepting responsibility at the time and making you all endure a lengthy trial. The statement I gave at my sentencing was shameful. All I did was talk about myself when 100% of my focus should have been on John and Patricia and the family they left behind. I've read and reread those transcripts over the years, and each time I'm filled with so much disgust. I hated the fact that you had to live all these years with those inconsiderate and uncaring words. I do care. I cared back then, but I was scared. I had no idea what the judge was going to do to me, and I lost my way, and I'm so sorry. I'd also like to talk about the bad decisions I made that night that ultimately cost John and Patricia their lives. I am deeply sorry, and there are no words that exist on this planet that can truly convey how I feel about what I did. No words can sufficiently capture how ashamed I am of myself, and I would forever spend a lifetime making amends and trying to cultivate a life worth being proud of. Your family lost a lot that night, and I don't want to sit here and characterize what happened that night as some sort of mistake, because it was much more horrible than that. The lack of compassion I showed that night was sickening. I should have done something to stop what was going on. I should have spoken up. Instead, I chose to walk around the house and look for valuables, when in actuality, John and Patricia's lives were the only things in that house that held any true value. That's what I should have been trying to preserve. But I failed them. I failed you, and I'm so sorry. The same disgust and shame that I felt back then still resides in me today, and that's my reminder that my work is never done. It's actually just the beginning. I want to always be the voice of goodwill and to speak up for the helpless, young and old. The night of my offense, which was Halloween, started out as two teenagers looking to scare kids on their way to getting candy. Once it got late, there were no more kids to harass. There was a conversation about stealing a car, then it somehow changed into doing a burglary. The house was chosen at random, but mostly because there was no car in the driveway. I didn't think anyone was home. Once I got in there and noticed there was an older gentleman sleeping on the couch, I should have turned around and left, but for some reason in that moment, I didn't want to chicken out. Not in a million years did I ever think that two innocent people would lose their lives. I should have went with my gut and just left, but at that time, in that particular moment, I was trying to act tough and prove something to my co-defendant, and I got caught up in the moment. And before I knew it, I grabbed John from behind the couch and I asked him who else was in the house. He didn't answer, but became very agitated. He started to pull me over the couch, and that's when my accomplice stepped in to subdue John. While John was being subdued, I went around the house looking for stuff. Not looking for anything in particular, but pretty much just going through the motions. Soon after, my accomplice met up with me in the kitchen and told me that John was unconscious and that his feet was taped together. I didn't think anything of it. I figured by the time he wakes up, we would be long gone. I went upstairs, and to my surprise, there was a female occupant. She was laying in bed, and I asked her if there was any money around. I think she said it was in the closet. I went looking for the money, and upon my return, my accomplice said he noticed blood around Patricia's mouth. At first, I was incredulous, but then I told him we should probably go. Everything was happening so fast with no clear goal, but once I heard there was blood, that moment of clarity finally kicked in and I wanted to go. I kept thinking to myself, why was there blood? What went wrong and how did I end up here? Being involved in a situation where I was going to leave someone in distress without offering some type of assistance. That's not me. How did I go from being a nuisance in my neighborhood to an accomplice to something so deplorable? The answer to that question has haunted me for the last 29 plus years. There are no answers, and even if there was, it would never rectify the wrong that was done. It would never fix the insurmountable damage that was caused by me. It would never fill that hollow void that has plagued the family and friends of the victims for years. I caused that. And there are no excuses, nor would I dare offer any. All I can do and all I've been doing is fixing whatever is broken inside of me, so I would never harm another individual ever again. I never left my house that night with a desire nor the intent to physically harm anyone. Nevertheless, my actions and inaction is why John and Patricia are not here anymore. Voices gave me a profound understanding of what my responsibility is to my fellow men and women. My life has changed a lot in the last 29 plus years. I am no longer a person just existing. I am a man living with a purpose, and my goal is to be a champion for humanity. I want to thank each of you members of this board for allowing me the long overdue opportunity to apologize to the Halls family. I pray that I haven't caused the family further pain through this proceeding. I also pray that they are no longer suffering and have found some healing. I beg their forgiveness, even though I don't deserve to ask. Once again, to the victim's family, from the bottom of my heart, I am truly sorry.
All right, thank you, Mr. Jones. And, you did send us, as I mentioned, a lengthy statement with many of the details of the positive things that you've been doing and your release plan. Okay, so Attorney, did you want to have her, Attorney Walcott?
Attorney Wolcott, if you can, please identify yourself for the record. And if you don't mind turning your camera on, please state your name, juris number, and business address for the record.
Yes, thank you so much. Just what? Okay. Name is Charmise Walcott. I'm the state's attorney for Hartford. Business address is 101 Lafayette Street, Hartford, Connecticut. And juris number is 401-898.
Thank you very much.
Okay. Thank you. So in preparation for your hearing today, this panel has reviewed your file extensively to include your police report, the pre-sentence investigation, court transcripts, your Department of Correction file that contains all of your programs, disciplinary reports, evaluations from the staff there. We have letters of support. We received letters of opposition as well. The summary of your interview with the parole officer and the memorandum submitted by your attorney, which includes reports from Dr. Hall and Dr. Pierre. So we do have some additional questions. We're very well versed in your case. When we're done with our questioning, we will ask the Office of Victim Services to facilitate any input that they have. And at the conclusion, your attorney and the state's attorney will have the opportunity to give statements. Okay, you'll have your decision here today before we leave. Do you have any questions before we begin?
No.
Okay, so I'll begin. And Mr. Jones, while we aren't here to retry your case, you were convicted and you, of course, admit to your involvement. I do have some questions about the offense itself. Okay.
Okay.
So I did read and listen to your explanation that you chose this house because you didn't think anybody was home. This was Halloween night. Do you recall the time?
Yes, maybe around 11:30.
11:30. Okay. So it's 11:30 at night on Halloween when most people would not be awake. And if they were not handing out candy, would not be answering a door, right?
Yeah.
Okay. So you say yourself, you went in through the garage, you see 2 cars there. So what would make you think that nobody's home?
I don't remember seeing 2 cars.
In statements, I mean, multiple statements throughout, there were 2 cars noted in the garage. Okay. So you didn't look in the garage at all. You just went in through the window and then went into the house?
Yes.
Okay. So if you didn't think anyone was home, why would you take a hatchet to the phone line before you went in?
I didn't know that that was a phone line. I thought at the time that it was probably like a burglar alarm system. So I was just trying to disconnect the system in case it was like had a silent alarm or anything.
Okay. All right. So then you get inside, you see that somebody's sleeping there. Why didn't you just leave?
I just want to say that at the time during the time this incident happened, I was very insecure of myself. I was trying my hardest to be something I wasn't. I was trying to be like my co-defendant who is a complete opposite of me. He's very confident, he's tough, and I myself is very weak and unassuming. So the whole 3 years that I knew this gentleman, I just spent most of the time just trying to impress him. And once I got into that house, I was just I was in way over my head, and I should have left. But I was so more concerned with my image to him than the welfare of that individual. And I lost my way, and I'm completely sorry.
Okay. I'm glad you mentioned your co-defendant. So the 2 of you were friends,
Yes.
right? Have you encountered him throughout your incarceration?
Just once when I was at Cheshire, and he got into some trouble and we had to swap jails. So I seen him in the AP room during the transfer, and that was it.
So you haven't spoken to him at all?
None.
So
Since-
it's coincidence that the 2 of you applied for commutations at the same time?
Yes. Pure
Wow.
coincidence.
And you're both receiving these 23-169 hearings as well. Are you aware that your co-defendant is basically saying the same thing about you, that he was following you, that he couldn't be a leader at that time, and this was all you, and that all of the physical aspects of this crime were committed by you, and he was in the background, doing all the things that you claim you were doing, searching the house and in the closet when you were harming the victims?
That would be false.
But are you aware that that's what he's saying?
No, I had no idea that's what he was saying.
Right. So it's rather disturbing to me that after almost 30 years, the victims' family members still can't get the truth about what happened that night. That's sad. You know, and nothing, of course, will make them feel better, but the little bit that could be given to them, the truth of what actually happened, they will never get, because they're getting different stories, conflicting stories, actually. We all know your story has changed multiple times, right? No?
Not to my knowledge.
Well, I mean, at the time of the court proceedings, you were claiming you weren't involved at all. They got the wrong person, right?
In the beginning.
Okay, so that's one version. You understand what I'm saying? You were there. It's
Yeah.
in all the official documents. That's one version. There's another version that you were there, but you didn't see anything that happened. You have no idea what happened, right?
In the beginning, what I wasn't able to articulate how I felt at the time, or what happened. I knew that I wasn't the person that physically took their lives, and I was just trying to separate myself from that part of the case. But I do feel responsible because I had no reason to be inside that house.
Yeah, I understand. Can you answer my question, please?
About the-
In fact, in your interview with the parole officer, you said that you know from reading the details, but you didn't see everything that happened. Right?
Yeah, I did.
All right. So that's two versions. And then the third version is that you were present and you did hold one of the victims while your co-defendant taped him up or whatever, and that you were in the room when the other victim was murdered. So that's three different versions, sir.
Yeah, that never happened. What I will say is that back then,
Okay.
when,
Go ahead.
what I will say is back then when the information was obtained, it was through, dictation. So I would say something and the detective would, record it. And, once you try to obtain information in that way, it's always the possibility that words and phrases could get misconstrued. So I wouldn't want to argue the facts of the case, but what I will say is that I'm responsible for the victims not being here. Being here anymore. I take full responsibility. There was absolutely no reason for me to be in that house.
Yeah, I mean, that's
That night.
obvious. We can all agree to that. Yeah. Okay.
Um,
All right. So we're going to move forward because we're going to, I don't expect you to change your story a fourth time here today, sir. I don't. I understand you take full responsibility and you are fully responsible. This is one of the worst cases I've ever had to read. So I can't imagine the horror that not only the victims went through, but the family members as well, living through this. And this wasn't the first time that you broke into a home, correct?
It wasn't the first time.
No. So who was responsible for the planning of the other?
The first time was like a friend of the family. I actually wanted to go to the house and just steal the car. Then once I got there, my co-defendant was like, "Why not just burglarize it and just go in there and see what we can get?" And I agreed, and it was wrong. After the
It was
incident
a friend of your family, so it was your planning.
to steal the car, but then once I got there, my friend was like, "Why not just go into the house?" And I agreed, and we went in there. And after the incident, I called the lady and I apologized to her, and she forgave me, but she was really upset that I allowed that individual to come into the house. So that was on me. I should have never allowed him to go into there.
Was that your mother's client?
Yeah, my mother worked for her.
Right.
And at the time, I liked stealing cars. And I knew that they kept the keys in the vehicle. So that was my plan, to just go and take the car to just joyride. And once we got there, the plans changed and he wanted to go in. So I didn't stop him.
Again, if you didn't bring him there, that could have never happened, right?
Yeah, you're absolutely right. Yeah.
Okay, at the time you were on probation, can you tell us about the assault third?
Yeah, it was at a mall, and we were, that's something that we used to do a lot, is go to the mall on the weekends, and we were cutting through this gift shop. We did it a couple of times, and the store owner was mad that we kept cutting through his shop, and then he accused us of stealing, and we weren't, and I got upset, and I lost my cool.
What'd you do?
I ended up punching him.
All right. You have done a lot of good programs. I'm going to move on from all of that. We read all of the excellent evaluations for the work that you've done, the programs that you've taken, your job performances. Probably most notable is the CNA work, right?
Yeah.
You want to tell us a little about that?
Yeah. The CNA work is something that I wanted to do for a long time. I wanted to do that and hospice. The reason that I'm in this position right now is because I lost my way. I was involved in a horrendous crime, and I wanted to somehow, some way, be able to just be a better person. And what happened after what happened to the victims, I just felt like I needed to do something good for someone else besides myself. So when I got to McDougal, I signed up for the CNA program, and they weren't really hiring or doing the training, so they just kept telling me to keep writing them. And that's something that I did for years, and I finally got the call. But before doing the CNA program, I did I got a healthcare aid diploma, and that was what kind of got the the ball rolling as far as that type of work. But I love my job. It brought out a side of me that I never knew existed. I got here, no other individual CNA wanted to work at this jail. So I decided, to come here because I knew they needed help. And as soon as I got here, I just got thrown right into the fray. I had a patient who had MS. I had another patient who was a stroke victim. And then I had a couple of hospice patients that I had to take care of. I didn't have hospice training in a technical sense, but once I got here and I had those patients, I just learned on the fly. So.
Okay. Another thing that was a little concerning to me was that, when you started to ramp up your program participation and this work, which came after the passing of 23-169, if we're being transparent, I read some of your requests for programming, and some of the language used was that, I need these programs for parole. So, oftentimes there's some criticism that inmates or offenders are only taking programs because they want to get out on parole. So, did you take those programs to look good for parole or to better yourself, sir?
When I got, there is probably, that was maybe one request. But there were plenty of requests prior to that where I was just wanting to do programs. I was having a hard time getting into these programs, and every time they wrote me back, it was pretty much, you don't have parole. So I just mentioned parole in those requests because maybe it would, trigger a better response. When I started, like my transformation back in 2006, I knew that the reason why I was getting into a lot of trouble when I was home is because I had no responsibility. I didn't have a job. I didn't, I didn't really care about nobody but myself. So in 2006, at that time, what was important to me was having some type of responsibility, and I wanted a job. I knew that taking programs was important, but when I was home, I was lacking confidence, and I needed that first and foremost. And that job that I had in Northbrook 1 in Cheshire gave me a lot of confidence. I was able to be more social. Guys were starting to come to me and ask for advice. It helped me to open up. When I was home, I was a bit of an introvert, and I didn't really, I wasn't really pro-social. That job allowed me to, be a better version of myself. And I thought that is what I needed at that time. And it also, having that job played a key role in jump-starting, me and my transformation. Once I had that confidence, and once I wasn't so, so insecure, I felt like I needed to move on and to do something different. And so that's when I got to McDougal. I signed up for everything they had. In 2018, I wrote to a counselor and I said I wanted to do anger management and a couple of other programs. I didn't mention anything about parole. She wrote me back and said, just be patient.
I'm sorry, what year was this?
This was in 2018.
Well, you had no shot at parole then. There was
Yeah, I
no
know.
parole for you. So why would you mention parole?
No, I was just going back to the question that the statement you made earlier about me mentioning parole in my request.
Yeah, that would be since 23 when this legislation passed.
Yeah.
But okay, go ahead.
Yeah, so she wrote me back and said, be patient. I wrote them again in about 6 months and they were a little bit perturbed that I kept, asking, about the same things. And I held on to those requests. Then in 2020, I did tier 2 and then COVID happened. So it was a little bit slow as far as programming. At the end of COVID, I wrote again for anger management and whatever, and I actually sent them a copy of that request, telling them, that I should be patient. And, they said, and I said, I've been patient enough. And I ended up, getting to be in anger management. But as far as the programming, like I said, I know my road uh, to in my transformation
Mhm.
was maybe a little bit unorthodox, but I felt that at the time that what I needed some confidence. I needed to not be so insecure, and that's why I felt like getting a job was important at that time.
Okay.
But like I said, getting that job and being more social kind of propelled me.
Right. Okay, we're gonna move on, okay? You're starting to repeat yourself, and I want to make sure we get all the questions that, answered that we have. So you mentioned you were insecure in your younger years and what have you. We read about your upbringing, and you had a good upbringing, a decent upbringing, right?
Yes.
You weren't poor, you weren't in the streets, your parents weren't involved in the system. So let me ask you this: why were you stealing cars, breaking into homes? Why?
I've been wrestling with that exact question since my incarceration. My co-defendant, who some might say lived on the wrong side of the tracks, was everything that I wasn't. He was confident, he was strong, he was tough, and he was fearless. On the other hand, I was timid, I was unassuming, and I was weak. I admired him a lot, and I wanted to be like him. For most of those 3 years I knew him, I spent a lot of time just trying to prove myself to him and trying to impress him. And it's crazy because I'm sitting here listening to these words come out of my mouth, and in retrospect, it sounds kind of juvenile to be so in awe of any human being, much less a high school classmate. But that was my state of mind back then. The night of October,
So are you saying that all of your criminal activity had to do with your co-defendant?
it didn't have to do with him, but once I met him, that's when I started to spiral. And I'm not blaming him, but it was my insecurities. I had some deep down issues that I was dealing with, and that's what led me to be involved in the situation I'm in. When I caught the assault third case, like all this stuff happened like once I met him. I was trying to impress him and trying to, live up
So
to
you
something.
didn't commit any crime before you met your co-defendant?
No, none.
And you said yourself you liked stealing cars.
Yeah, this was during that time.
And did you have financial trouble with a bondsman? Did you owe somebody money?
No, not that I know of. If my mother did something with a bondsman, she didn't tell me about it.
So you didn't need the money either.
No.
I do want to point out, we received a lot of letters from fellow inmates, patients that you've cared for, family members, your cousins in Canada. I think I'm done with my questioning, and I'm going to turn it over to my colleagues because, of course, we want the victims to have the opportunity to speak as well. Ms. Turner?
Good morning, Mr. Jones. So during this time of 16 to 19, when you knew this co-defendant, you graduated high school and you took the qualifying tests to enter the Navy, correct?
Yeah, that's correct.
Okay. So why do you think you decided against such tremendous opportunity?
It was just my view of the Navy at the time. It's kind of like childish now that I think about it, but I just thought that the Navy was just, a bunch of guys on a ship, just in the middle of the ocean. I never knew like the details of what they do, how important it was, and I just felt like I just didn't want to sit in the middle of the ocean in a boat.
So why there are so many other branches of our service? If you didn't want to be on a boat, why didn't you look at the Army?
Well, actually, the Navy came to me. I didn't even know about it or was thinking about it. I came home from school one day and the recruiter was in the living room talking to my parents. And my dad was all for it. So that's why I decided to do it. They came looking for me.
So if your dad was all for it and you passed the tests, again, why didn't you go?
And just being immature. I really didn't know. I really didn't know what the Navy was all about until
I did hear you
I
say
came
that.
in.
So what I read was that you and your co-defendant cut through the golf course the night before and approached a different house, but you heard a dog barking, so you left. Did that happen?
No, I don't remember that. That never happened.
So why did you go armed with a miniature bat?
Not me. The only time I found out about a bat is when I came to jail and I read the discovery. I didn't know that he had a bat with him. From the moment
I
I
also
went,
read it was your bat. So this is
No.
starting to get ludicrous.
No,
Okay,
that wasn't.
so you didn't bring a bat. Why did you have tape with you?
I didn't bring tape. That
So
wasn't me.
you and your co-defendant met up, cut through the golf course, picked this house, and you never saw that he had duct tape and a bat with him.
No. One thing I would say is that from the day I met my co-defendant, he always carried either a book bag or a duffel bag with him. So he would often have, a change of clothes in his book bag. He would have a
right.
notepad.
Okay, so I don't need any more details on that. My interpretation of what I read, which were statements that were made to the police, dictation or not, and the bat was because if there was another dog, you were going to subdue the dog with the bat. So you didn't know these victims, correct?
No.
So I'm just going to tell you, Mr. Jones, I really object to you referring to them by their first name throughout your letter to us. You don't get that privilege. You didn't know them. You were responsible for taking their lives. You're not familiar with them enough to call them by their first names. So that really felt disrespectful to me when I read that. So you spoke of developing a moral compass since you've been incarcerated. Do you remember writing about that?
Yes.
So why don't you describe to us what your moral compass is?
Well, my moral compass is being more compassionate towards other people, more empathetic. I sort of lost my way. Like you've heard, I grew up in a pretty good household.
Okay, I'm
And
going to stop you because the question was for you to describe to me your moral compass. So I have compassionate and empathetic. What else
Yeah,
is part of who you are?
oh yeah, just giving people more grace, and just knowing that everybody's going through things, and when you see somebody upset with you, you shouldn't take it personal. So I've learned throughout my days in here is just to give people more grace and be more compassionate and more empathetic towards people.
Moral compass is usually that guidance within ourselves that keeps us on the right path.
Yeah, that's
When
where
temptation and poor peers try to influence you, a moral compass is your inner voice that says, I'm not doing that. Or
Yeah,
that's too far, that's taking it too far. So
Yeah,
what else can you share about how
well,
you believe in conducting yourself in the world, regardless of what's going on around you?
Yeah, no, that's a good point. I've been faced with a lot of things throughout my incarceration. I just was talking to my lawyer about this not too long ago, where guys would come up to me and offer me contraband, and I would tell them no. Guys will come up to me and ask for advice on whether they should harm another individual, and I would try to guide them in the right path. I've been more attentive to people and their needs, and I've been a voice of reason since I've been in here. There's countless times where situations would be happening in the block, and I would, do my best to try to smooth it over and give people a better outlook and a better, more resolution.
Offering perspective.
Absolutely.
This is your champion of humanity that you mentioned earlier.
Yes.
So you had very little, if any, work experience before you came into prison, and you've been now working as a CNA for 2 years. Did you have other jobs in the facility?
Yeah, I worked as I guess you would say like a janitor.
Okay.
In the beginning, I worked in commissary.
So describe for me your work ethic.
My work ethic is amazing. I've been promoted so many times, it's ridiculous. I enjoyed working because it gave me, in a small way, it gave me purpose. My work ethic is I do a job and I do it to the best of my ability, no matter what the job is. My first job was probably cleaning the showers.
Okay.
Yeah, it was probably cleaning the showers, and I try to do that to the best of my ability. Even though it's like one of the worst jobs in prison, but yeah, I try to approach my job the way I approach how I deal with people. I just give it my all and I do my best.
Anything else?
As far as jobs,
Work ethic, sir.
work ethic, yeah, like it doesn't like being like a CNA. They wake me up at 2:00 in the morning to go to work, and I do it, without complaint. They wake me up all the time, 2 or 3 o'clock in the morning, and I have no issue with it. I'm always on time. I never complain, and I just
Okay,
do my best.
so when you get out into the community, you're going to have to represent yourself to potential employers. And you're going to have to be able to describe not the jobs that you do, but how you approach the work. So I'm looking for, you work as a team well, you take direction from your supervisor, you respect your superiors, you stay until the job is done, you follow direction. Those kinds of things make up your work ethic, and that's how you would represent yourself.
Okay. I think I didn't understand the question, and I wasn't really able to articulate it, but you're
Okay,
absolutely
but
right.
you do know you use that expression in your letter, so you have to be able to substantiate the phrases, the cliches,
Yeah,
go
absolutely.
ahead. Like moral compass, work ethic. Okay, so anything else you want to say about your work ethic?
No, but exactly what you just said. I know you've seen some of my work reports, and my employers actually said just that. Like, work well with others. I show up on time. I make sure the task is completed so that as best as it could. I don't really need a lot of instructions. They can pretty much just give it to me, and I'll, they know that they can trust me to get it done.
You mentioned to my colleague that your insecurity was due to deep down issues. Is that anything that you could unpack and share with us? And how you've resolved those issues?
No, I was like I said earlier, when I was home, I was an introvert. I pretty much stayed to myself. And that's why I wanted to get that job so bad in 2006. And it kind of helped me to be a little bit more open. And it gave me confidence. And that's one thing that I was lacking when I was home. I had no confidence. I know I had a good upbringing, but my confidence was really low.
I understand, Mr. Jones, that you're nervous, but I'm going to ask you to really focus on the question that's asked of you. You shared with my colleague that your insecurity was due to deep down issues. And I just asked you if those are issues that you'd be willing to share with us and how you resolve them.
Yeah, well, the deep down issues was I thought I was worthless. I don't know how I got there, but that's how I felt. I felt like I was unseen, and it bothered me for a long time. Once I got in here and I was able to be a little bit more open and put myself out there, I saw something in myself that I never knew I had, and that was, the gift of compassion. I was able to be someone that can give somebody advice, or just lend somebody a ear.
Have you figured out why you felt worthless? And that's huge. Have you ever talked to your mom about it?
No, never. We just didn't talk about those things in my house. But I know I was dealing with it. It's kind of like when you have low self-esteem, it's kind of like when somebody is think that they're ugly and you're looking at them and you're like, what's wrong with that person? They're beautiful. Like, having self-esteem is it's a tricky thing. And even though I came from a good family, I still felt like I wasn't enough. And I don't know what brought me there, but I know that I'm not that person anymore. And it's sad that I had to, come in here, to realize my full potential. But
I think what's really sad is that you had an opportunity, being accepted in the Navy, to actually step up and build your self-esteem. It's not something that you're given. And instead, you chose the path that your co-defendant was on, and you followed him right down the rabbit hole. If you were really unsure of yourself or feeling insecure, taking that step with passing the test for the Navy should have made you feel tremendous about yourself, and having your dad's support. And just, it is a curiosity to me, and it's proven to be immeasurably tragic. I don't think I have any more
Thank you.
questions.
Thank
Madam
you,
Chair.
Ms.
Thank you, Mr. Jones. Mr. Rodriguez?
I don't really have any questions, Madam Chair. Just a couple of things. I mean, just in a way, it is very tragic in a way, because yes, you shared before, you came from a pretty good family who seemed to be supportive of you in a lot of ways. Even when it came to the Navy, you said your dad sat down, talked with you about it. And so there's some inconsistencies even in when you share that kind of information, along with the inconsistencies of this offense. I don't really have a lot of questions, but I think my colleagues covered a lot of it.
Can I ask one more?
Sure.
So, Mr. Jones, you got 108 years sentence because you took this to trial. Your co-defendant got 80 years. You served 30 years of a 108-year sentence. How do you think the family members of these victims feel with you asking for release after just 30 years?
They would probably be heartbroken. They would probably feel like I don't deserve it.
I think they're probably angry at the system, because, the sentence now, things have changed with new laws passed. They give you this consideration. So maybe they feel that justice didn't really work out for them. Does that make sense?
Yeah, that makes sense.
You did tell Officer Wangertsman that you thought your sentence was fair.
Yeah, because I knew that I went to trial, and I think the judge's hands was tied, because I had a lot of charges. So when you count up all the charges that I had, I think that's why the judge gave me that number.
Well, I'm not sure about that, but I would say that you were responsible for the deaths of two absolutely innocent human beings. I mean, you can't get more innocent than being asleep in your own bed in your own house when you're killed. And for the family members to really reconcile the fact that you and your co-defendant were the last people these victims, their loved ones, saw on the face of the earth, there to do them harm. And, I also read that after the gentleman was killed, you refer to it as subdued, and you loaded items into their vehicle to steal, that you went back into the house, and then going upstairs is when you encountered the victim asleep. And it just, one of the things that occurred to me while I was reading this account, which I agree with my colleague was incredibly disturbing, you could have taken anything out of that room and left her alone.
Right.
But instead, she was woken in a state of absolute terror by two men she didn't know in her home, trying to steal from her and ultimately taking her life. Just, there's so many opportunities during the commission of this crime that you could have stopped and done something different. Just brought it to an end. So, okay.
Thank you. All right, this time we'll ask the Office of Victim Services to facilitate input from the victim's family. Ms. Vasquez, thank you for joining us.
Good morning, Madam Chair and board members. I had the opportunity to speak with um, the victim's family to a very lengthy and extent nature, and their son would like to read his own statement, and then after that, I'll be reading a couple of statements that were submitted. At this time, thank you. At this time, this will be your opportunity to express to the board your wishes and concerns. You may unmute your microphone, and if you are able to do so, you can turn your camera on and you may begin.
Oh, damn it. Hi, can you hear me?
Yes.
Yeah, my camera won't work for some reason. I apologize. But I would like to read this letter if that's okay.
Thank you.
I was 29 and a half years old in November of 1996. On November 4th, I received a phone call that my mom and dad had been murdered during a home invasion. I'm now 59 years old, and my life is quite literally bifurcated into before and after. Who I was before this senseless, vicious, and quite intentional crime, and who I am in its aftermath. I received another phone call 2 weeks ago informing me that Roger Jones is seeking an expedited parole hearing, as is his right with the recent SCOTUS ruling regarding convicted murderers whose crime was committed before they were 21. Mr. Jones has been seeking to appeal his conviction in the 108-year sentence he received in lieu of the death penalty, essentially since he was sentenced. When I received that phone call 2 weeks ago, the maelstrom of pain and grief, it wasn't dredged up from some long sealed vault. It's under my skin every second of every day. Mr. Jones has never taken responsibility for the crime or shown any remorse save for his unctuous and wholly transparent apologies during sentencing. Despite the overwhelming evidence presented during the months-long trial, he seemed to feel he was somehow the victim. It was almost incomprehensibly insulting. Apart from various appeal notifications, that was the last we heard from him over the last 25 years. Of the two defendants in this case, there can be little doubt as to who was the quote-unquote brains of the operation. In fact, his accomplice Von Walker stated at his sentencing for the 80 years with no parole plea bargain he accepted when taking responsibility that his biggest mistake was listening to Mr. Jones. I watched Mr. Jones every day during the months-long trial. I watched daily as the judge and jury would leave the room and his mask would drop into a dispassionate gaze of feral cunning that would be revealed. He seemed irritated and almost amused, despite 5 years in jail, to contemplate his horrific actions and their consequences. The bottom line is he went to my parents' house that evening armed with weapons and materials to subdue anyone they encountered, intent on committing a robbery, no matter what the cost. After they struggled with my father, beating him viciously with a wooden bat, leaving him in a pool of blood, he could have fled, but instead chose to tie my father up, leaving him to bleed out on the floor before proceeding upstairs to awaken a 69-year-old woman from her sleep and beat her and smother her to death. Now, Roger Jones is not a victim of his environment or his circumstances. He's a stone-cold killer who has shown zero remorse, let alone basic accountability. And I would ask as fervently as humanly possible he not be granted parole at this time. He should not be eligible for another hearing until 2050, under the sentence he received after an arduous trial, proving his guilt beyond a reasonable doubt to a unanimous jury. His crimes are senseless, horrifically violent, and absolutely on purpose. And for what? A VCR and some credit cards, a car you couldn't even use? I miss my mom and dad every day, and 30 years later, it hurts just as bad. It's just as senseless, it's just as cruel, and that profound loss will never change. My son is almost the age Roger was when he took my parents' life, stealing them not only from my sister, myself, their siblings, and family, but robbing him of his grandparents as well, grandparents he will never know. I have no doubt that should he be released, Mr. Jones will commit more crimes and cause another family the same amount of pain and wreckage. I also don't see how it's fair that the one who took responsibility accepted 80 years in prison and you want out after 30. I'll close with an anecdote from their confessions describing when Mr. Jones and Mr. Walker laying low at a friend's house waiting for the bodies to be discovered, and the young woman's mother came home very visibly upset. When the young lady asked her mother what the matter was, she replied, "Somebody killed my doctor." The gigantic hole Roger Jones' actions left behind has not healed yet for anyone who knew my parents. It probably never will. Certainly not for my sister or myself. The attached photograph was taken for their local parish directory, ironically on the day of their murder. Thank you for your consideration.
Thanks, sir.
Thank you for your statement. Now I will read the statement from his sister. Dear Ms. Vasquez and members of the Connecticut Board of Pardons and Parole, thank you for your letter dated May 5th regarding the parole hearing of Roger Jones, inmate number 243897. I respectfully request permission to attend the hearing and submit this victim impact statement in unequivocal opposition to his release on parole. Roger Jones was convicted of murdering my parents 30 years ago. Nothing in the decades since has been diminished the gravity of the crime or its impact on my family. I have seen nothing that would justify his release, and I respectfully urge the board to deny parole. What was taken from my family can never be restored. My parents would have continued serving their community, supporting their friends, and loving their children and grandchildren. Instead, after nearly 50 years together, they were killed in terror and pain. My brother will speak for himself. I will say only that he continues to live with severe PTSD. This crime profoundly damaged his life, and I remain concerned about the effect Roger Jones' release would have on his mental health. The impact of this crime remains with me every day. I still awake in the night if I hear a noise, afraid someone is in my home, and I lock my bedroom door when I am alone. Holidays and family gatherings remain lasting reminders of what was taken from us. These are not memories that faded with time. They are the enduring consequences of what Roger Jones did. For much of my life, I carried this grief in silence, even with those closest to me. Speaking about my parents' murders has always been extraordinarily difficult, but their lives mattered, and what was done to them must be fully acknowledged. When I joined a homicide survivor group, I heard story after story of lives permanently altered by violence. That experience reminded me that my parents deserve to be remembered and that the harm caused by their murders did not end when they died. Roger Jones changed the course of my life and my family's life forever. I submit this letter because my parents did not deserve to die in fear, through violence, at the hands of someone who made deliberate choices of every step. Roger Jones planned a robbery and entered my parents' home armed and with intent. He and his accomplice knew people were inside and proceeded anyway. They attacked my elderly father, and after killing him, chose neither to leave nor to seek help. Instead, they went upstairs to confront my sleeping mother, demanded money, and when she had none, smothered her. These were deliberate acts. This was not an accident, a moment of panic, or a crime of passion. My parents' murders continue to shape my life in ways both visible and invisible. I miss them every day, and I grieve not only who they were, but also all the years we should have had together. That loss is permanent, and so is the harm caused by this crime. The deliberate and sustained nature of these murders, the complete disregard to my parents' lives, and the permanent harm that to my family all weigh strongly against parole. Granting release would not reflect the gravity of this crime or the lasting damage it caused. It would also reopen trauma that my family has carried for decades. Thank you for your time and consideration for the sake of my family and in recognition of the lasting harm caused by these deliberate murders. I respectfully urge the board to deny Roger Jones parole and maintain a sentence proportionate to the gravity of his crimes. Sincerely, E.H. To whom it
Thank
may
you.
concern. I have two more to read. Thank you. To whom it may concern. This letter is being written as a statement concerning the parole request of Roger Jones after being convicted of several charges related to the murder of my sister, Patricia Haw, and her husband, Dr. Joan Haw. We are concerned that while this situation offers tragedies on many levels, including in the lives of the perpetrators, there still remains a fact related to the brutal loss of life of our family members. There is nothing that can compensate our family or community for the loss of two very vibrant people. We cannot imagine what the world could have known had the lives of these two people not been brutally taken from us. It is painful to think about it even after 30 years. Thinking about this opportunity for parole brings up all the grief, stress, and fear that this family murder brought us. Even our children who are now in their 30s remember the stress and fear that the facts of the murder brought to their childhood. Our questions ask, what are the long-term ramifications of these ripple effects on our family and community? If the perpetrator is allowed to be paroled, then does it mean that the loss of the lives of our loved ones did not count? We have several concerns. Does Mr. Jones take responsibility for his part in this terrible crime? We noticed that he tried to vacate his charges in 2007 by citing improper instructions to the jury. Does this mean he did not and does not take responsibility for his conviction? We also noticed that during that trial, he claimed innocence. Is that still his stance? Does he have any genuine remorse? We are also concerned that Mr. Jones is still a relatively young man. If he has not done anything to remediate his life, then he will be a risk to society with potential to harm others. Has he undergone any type of self-reflection or treatment related to what led to his horrible crime? We recognize that the prison system is an imperfect solution to protect society and that people in prison have the potential to be worse after time served than they were before they went into the system. What has happened to Mr. Jones while in prison, and is he going to pose a threat after he is released? We do struggle with the concept of consequences and the meaning of life sentences. What is the point of a life sentence? What was the jury thinking as they offered a sentence of 108 years? Was the sentence to punish the perpetrator or to keep society safe? Do life sentences tell the population at large that the community does not tolerate home invasions and murder? Even though 30 years is a long time, it seems like only yesterday as we relive our trauma to this loss and reflect on the ripple effects. Does taking a life, or in this case, 2 lives, mean that you lose your chance to have a typical free life? We think that the unnecessary and cruel crime necessitated a real-life sentence and would make sense as the future unfolds. Thank you for the opportunity to share our thoughts in this matter. Sincerely, RC and TB. And lastly, to whom it may concern. I am writing to express my opposition to Mr. Jones being paroled from jail. He took part in the murder of my aunt and uncle, who are deadly missed. They were very giving people who served their community and were sadly taken too soon. I feel it would be an injustice to release someone capable of brutally murdering them without serving his entire sentence. Mr. Jones is a young man who I fear may get out and commit more crimes against another family. Please do not grant parole to Mr. Jones. Sincerely, CC. Thank you, Madam Chair and board members. This is all I have for this case.
Thank you, Ms. Vasquez.
Thank you. So at this time, each of the attorneys will be afforded an opportunity to make a statement We'll begin with State's Attorney Wolcott. If you wish to proceed to make any statements, you may do so now.
Thank you. Thank you, board members. Thank you to the family. I do want to start just by clarifying and correcting juris number. The office juris number for the record is 423-818. I do not have a very lengthy statement today. And I came into this hearing, as I often do, hoping to hear something that kind of changes what I may have initially thought after reviewing the file. But I walk away, or I stand here now with the same thoughts. This was a heinous homicide. It's absolutely disgusting what happened to these poor people and their family, and it didn't need to happen. But it's not impulsive. This is not the sort of criminal activity that I think many in the criminal justice system thought of when we started granting review hearings for juveniles who commit crime. It's the impulsive crime. It's that crime that says, you know, that's based on lack of mentors, lack of a mother and father in the household, and you know the juveniles living on the street and with no other way. This defendant, Mr. Jones, is none of those. He actually talked with his father about enlisting, as a member commissioner pointed out. He had options. He had choices. He actually picked his victims based on the places his mother worked. What a slap in the face to her and all that she had tried to do. And then today in this hearing, when he was being questioned about, you know, just various questions that really led back to responsibility, and on each one he indicated that he takes no responsibility, truly. And it's not just no responsibility for this crime, but it's no responsibility for anything that he's done in his life. When we looked at, you know, the enlisting in the services, well, they came to me. I didn't really know what it was about. When we look at the homicide, oh, I was just there. He says he didn't bring the bat, that it wasn't his idea, that he didn't plan it, but prior burglaries he did. And then when he's even asked about something as simple as, was there an issue or dispute with the bondsman? He says, no, that was my mother. Incarcerated for 30 years, and he's still sitting here blaming his mother for something. This is a person who received 108 years for a heinous crime. It's part punishment. I hope he does rehabilitate when he's in there. Because at some point, if at some point he makes it back into society, he should not and cannot come back into this community, Hartford community, or really any community, behaving the same way that he behaved at a time where he had significant supports and choices. So states against the any sort of reduction. I will note that, and I'm sure the commissioners have it, he has been ticket free for 20 years, which is great, but he had 10 significant tickets before that, including, you know, just flagrant disobedience. But I think the biggest signal that he's not ready to receive any reduction in his sentence are his own words and actions here today. So thank you for the time.
Thank you, Attorney Walker.
Thank you. At this time, Attorney Conway, if you have any final remarks you would like to make, you may do so now.
Thank you. Yes, I will. Before I address my brief statement, I would like to say that Mr. Jones and I talked a lot about the statement that he submitted to the board, the written statement in which he addressed the victims by name. And it was important to him and to me that he did so because he has recognized that their lives were the only thing of value. And to us, it felt sort of the opposite. It felt disrespectful to not give them a name, to not say that their lives mattered. And so I want to take full responsibility for that and apologize to the board.
Perhaps Attorney Conway, I'll just interject. Dr. and Mrs. might have been a little more appropriate. But thank you.
I understand. Also, to the state's point about how these hearings are to provide review for those under the age of 21, the state mentioned that is for an impulsive act for defendants who do not have guidance or mentors. But I want to say that not just impulsivity is a hallmark of youth. Mr. Jones mentioned over and over in his packet and here today that he had a good family, but there was lots of things that they did not talk about at home. They did not talk about his feelings of worthlessness. They did not talk about depression. They did not talk about needing to fit in with people that were not the right type of people to fit in with. Mr. Jones mentioned a lot between the age of 16 and 19 that the crimes he committed were because of the group he was with, and that is indicative of what we're here for today. He was young, he was choosing the wrong path. He had an opportunity to enter the Navy, which he very much should have taken, but instead he was trying to impress the peers that he found who had no mentors, who had no guidance, who were living the street life. And we all know, by nature of being in this work, that for some kids, especially kids like Mr. Jones, who had no self-esteem, who felt worthless, who had no guidance, who felt lost, sometimes the clout and the confidence and the strength that appear enticing with street life is what they fall prey to. So I would like to keep in mind that Mr. Jones, although this was not an impulsive crime, and we fully recognize how heinous and awful it is, the reasons that he found himself in these situations are also hallmark natures of youth. Now, I will be brief for the rest. I've spent much of my time in working with Mr. Jones over the last few years, and most recently the last few weeks, trying to figure out how to articulate to the board who Mr. Jones is and how good-natured I've come to know, his good nature that I've come to know, how rehabilitated he is, how much work he has done over the last 30 years, and how many people he has positively impacted during his time within DOC. And I've struggled, not because those things are not true, but because I've spent almost 2 years learning these things about Mr. Jones, and we have just about 2 hours this morning. Within his packet, I know the board has fully read it. There were statements from patients of his, as I think the chair pointed out, patients of his, family members of his patients, fellow inmates, good work reports from DOC. There were assessments, there were certificates, there were hundreds of pages of things that show Mr. Jones's growth over the last 30 years. There are statements from his own family and friends that explain the positive impact that he has had on them while being incarcerated. There was mention that he has been consistently employed by some sort of unit within DOC since 2006. I know that Mr. Jones had mentioned in 2006, something inside him just switched, and he felt that the thing that was going to help him change the most was obtaining a job, having a structure, learning from people that are going to be, working with him, that he's working for. I don't know that Mr. Jones articulated his answers thoroughly enough, but he and I have talked about how much his employment over the last 20 years has meant to him. I know that the board, after today, after this conversation, there are always concerns about if someone is going to be released on juvenile parole, what might happen. Mr. Jones has demonstrated for 20 years that he has not engaged in any poor behavior. He has no DRs. The 10 tickets that he did have prior to 2006, none of them were violent. They were, one was flagrant disobedience, but they were all explainable. I know that, and we're not going back and forth with questions here, but Mr. Jones has no issue explaining what he did wrong to obtain those tickets. Mr. Jones has done all the work, especially in the last 20 years, to make sure that each step he takes going forward is not only a positive step for him, but for those around him. There is nothing that any of us here could do or say that can undo the pain and hurt that he caused on October 31st of 1996. I don't think that there's any expectation by Mr. Jones that this hearing would do that. This is something that he never expected to even be given the opportunity for until the last 2 or 3 years. He and I have often talked about how he will continue to spend his time, regardless of what happens here today, to make sure that he leaves positivity in his wake, no matter who he comes into contact with. Mr. Jones's transformation, as he mentioned, was permanent. It was intentional, and he intends to keep that going no matter where he resides, be it here in DOC or in Canada, as he does have a federal detainer and will not be able to remain in the United States. As the CNA in DOC, the impact that he has is limited by who he comes into contact with in the medical wing at Oregon. He has plans, though, if he is released, to continue that work on the outside, where he will have, hopefully, when he is released, an impact that will be much broader than who he comes into contact with here. Mr. Jones is not someone who began changing or doing programs just so that he could one day appear before the parole board. As we've discussed, for him, parole was never even an option. The work he began doing on himself started in 2006 when he realized, now as an adult, I believe he was around 20 or 29. So after his brain had fully developed and after he had time to reflect on who he was and the choices he made, that he needed to change for himself and for those around him. I would further rest on everything that I provided in my written statement to the board by asking that the board humbly grant Mr. Jones's application for parole pursuant to 23-169.
Thank you, Attorney Conway. Okay, at this time, the panel will deliberate. You can listen to our deliberation. Mr. Jones will come back to you shortly with our decision.
Okay.
And I, of course, want to start by thanking the family members of the victims here, Dr. and Mrs. Hawk. I can't imagine what they've been through over the years thinking about this horrific crime. All right, so let's talk about Mr. Jones. Mr. Jones was 19 years old when he committed this crime. He is now 48, serving almost 30 years of his 108-year sentence because he did go to trial. So the public act that we're here for, or as a result of, asks us to look at 3 things when considering whether or not we might use our discretion to grant parole. Those things are whether there's a reasonable probability that such person will live and remain at liberty without violating the law, whether the benefits to such person and society, benefits of release substantially outweigh benefits of continued incarceration, and whether such person has demonstrated substantial rehabilitation. I unfortunately cannot find those 3 things here today. I do not feel confident that there's a reasonable probability that Mr. Jones would remain in the community without violating the law. The benefits of release versus incarceration, well, sure, we can argue both ways. He is doing good work in the facility. He's getting paid to do a job, but I understand that being a CNA is not an easy job. What I struggle with probably the most is the rehabilitation. I don't see that in his presentation here today. I don't necessarily believe that the remorse is genuine. It's just, this is such a heinous crime. The callousness shown during the commission of this crime is just unimaginable. We're getting conflicting stories, but put that all aside. They were both there. They both participated in this crime that we don't often see. As the state's attorney mentioned, that usually these cases are very different, and they are impulsive crimes committed by youth, very young people. I believe this was planned. I do. And it's just too much. I don't find the elements necessary in the Public Act to be here today. And my vote today will be to deny parole. The Public Act requires at least 2 years for a rehear. If we're to rehear, certainly a 108-year sentence is very long. So I do believe that this case should be reheard, but I'm not interested in having the victims' family members go through this in the near future. So I would be interested more in possibly 10 years for a rehear. So those are my reasons, due to the nature and circumstance of these crimes and the injury and impact to the victim and the victim's family members. Ms. Turner?
I honestly agree with everything that you said. I would certainly add the offense was on probation. To realize that the family members were struggling with the impression that Mr. Jones left in that courtroom throughout the trial, but then his statement at sentencing. And that's what they've had to grapple with for 30 years. You know, I give him credit for, you know, embarking on change, wanting more for himself and his legacy, to be there to help others. This is, I guess, the amends that he spoke of. I struggle a bit with some of the language, because I think it's what we have to express how we feel and what we think. And his choice to talk about Mr. Ha as subdued when he was killed is, again, you know, keeping himself from being fully accountable. He talked about being unable to articulate in terms of the crime, but, you know, to me, it was being unable to really be responsible. To describe the Mrs. Ha as laying in bed, like that wasn't at all what, you know, it's so much worse than that. And so some of that is concerning to me. But I think 10 years sounds about generous.
Thank you. Mr.
I
Rodriguez?
also acknowledge what you said as well. This offense is just so much to kind of grapple with. And the fact that for me, it sounded very like he was minimizing a lot of what happened. This had to be a very traumatic scene to begin with, since both were bludgeoned.
Right.
It could not have just been so simple as to be subdued and a little blood coming from the nose. I just couldn't follow that at all. It didn't. And although I want to acknowledge his change as well. I do want to acknowledge that, but it just didn't seem to me as if he was taking responsibility for this. I just didn't get that sense. Even though
I don't necessarily see the change, if I'm being honest. I see the work. I do see the work.
Yeah, that's kind of what I meant. I see what
is giving
put
back.
into.
Yeah,
putting
okay.
into. But I'm also in the same place. And I think
Okay.
10 years is also very, you know, very.
Well, I mean, you know, we could discuss something different if you,
Yeah.
if you.
No, I'm fine.
Okay, 10 years, okay.
Did you want to include inadequate evidence of offender change? I mean, that's certainly more relevant than offense on probation.
I would, yeah, I wouldn't include the offense on probation, but I don't know, what are your thoughts on that? Do you think it's appropriate?
I do,
All right,
because it's factoring in here very heavily.
It was
all right.
nature.
You're both fine with 10 years? Okay. Nature and circumstance and victim impact and inadequate evidence. All right, in the matter of Roger Jones, MA number 243897, move to deny parole for the following reasons: the nature and circumstance of the offenses, injury and impact to the victims and their family, and inadequate evidence of offender change. We'll rehear the case in 10 years, the year 2036. Is there a second to the motion?
Second.
All in favor?
Aye.
Aye. Thank you to everyone for your participation here today.
Thank you.
Thank you. This Public Act 169 hearing. Inmate 243897. It is 10:30.
We'll take a
also has a
Hartford.
the following Good morning.
My name is Parole Officer Logan. Today is Monday, June 15th, 2026, and this is a Public Act 1584 hearing of the Connecticut Board of Pardons and Paroles. Mr. Santana, for the record, the state of Connecticut passed and made effective October 1st, 2015, Public Act 1584, an act concerning lengthy sentences for crimes committed by a child or youth and the sentencing of a child or youth convicted of certain felony offenses. You fall under this act, and basically this means that you were under the age of 18 and that the board shall give weight to the diminished culpabilities of juveniles as compared to adults, the hallmark features of youth, and any subsequent growth and maturity that you've displayed while we are reviewing you for suitability today. The following board members are present this evening, and by stating their names on the record, certify they have reviewed all statutorily required documents in preparation of this hearing.
Good morning, I'm Jennifer Zaccanini.
Good morning, panel member Rodriguez.
Nancy Turner.
Also present is the board psychologist. Also in attendance this morning is the public defender. Can you please state your name, juris number, and business address?
Good morning. My name is Dean Valladata. Juris number is 439908, 101 Lafayette Street, Hartford, Connecticut.
Thank you, Attorney Valladata. Is the state's attorney present?
Who else is present in the?
They are not connected.
Good morning.
Okay.
Can you introduce yourself, sir?
Yes, good morning. My name is Brian Abbott, Public Defender Social Work, Hartford Superior Court.
Thank you, sir. Let the record reflect there is no one present from the state's attorney's office. Also present is victim advocate Vasquez. Mr. Santana, please state your name and inmate number for the record.
Lorenzo Santana, 422119.
Mr. Santana, this is a public hearing in accordance with Chapter 14, Freedom of Information Act, Connecticut General Statute 1200, which applies to this procedure. If you have any questions concerning the above, please bring your questions to the attention of the panel at this time.
No questions.
Are you willing to proceed at this time?
Yes.
This 1584 hearing is being conducted in consideration of the parole application for Lorenzo Santana, who is serving 15 years execution suspended after 11 years, followed by 5 years probation for manslaughter first, intent injury. There is victim input in this case. There is an offender accountability plan for the offender. It has been reviewed and shows he has completed good intentions, bad choices, true choices, young adult, voices. He's completed several semesters of college. He's also completed anger management, people empowering people, basic credit seminar, resume writing, career choices, conflict resolution, reflections, thinking outside the box, building on character, smart recovery, master class in mentoring, introduction to culinary arts, and he also has an OSHA certification. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score on the RT falls within the moderate range of risk for recidivism. Mr. Santana, this is your opportunity to express to the board why you believe you should be granted parole. You may begin.
Thank you. I would like to start by thanking the Board of Pardons and Parole for this opportunity to express myself and share my growth and development over the 9 years I have been incarcerated. Most important is I want to acknowledge the victim and the family of Gabe Bartle, his parents Jeff Bartle, Anna Barra, and grandfather Brian Bartle, as well as take full responsibility for my actions that led to Gabe Bartle's death. My actions that resulted in Gabe Bartle's death were completely wrong and immoral. I'm very regretful for my actions and how they affected not only Gabe Bartle, but also his entire family and friends. On August 5th, I took the life of Gabe Bartle, someone's son, brother, grandson, and friend. I woke up that morning to my mother yelling that breakfast was ready. My co-defendant, my brother, and I were sitting at the table enjoying pancakes when I got a text message from my other co-defendant and asked if we wanted to smoke weed. We said yes, and she arrived at my house with 2 more individuals in the car. When she arrived, we got into the car and drove off. I asked my co-defendant for her weed so we could start smoking, and she said that she didn't have any, but knew someone we could rob, and we agreed. She messaged Gabe and he told us a location that we can meet. Once we arrived, the driver and I got out of the car and approached his vehicle. He rolled down the window and handed me the drugs. Once I had the drugs in my hands, I told him that I'm not paying and flung the cigarette I was smoking at him and followed by a punch that missed. As he was driving away, my co-defendant got out of the vehicle that we arrived in and jumped on the hood of the car, but landed on the windshield, which caused Gabe to stop. My co-defendant screamed my name and told me to get out, thinking he was driving away with me. Once he realized I wasn't in the car, he told Gabe to get the fuck out the car, and he did. Thinking about that situation, I can only imagine how scared he was. Standing there, I asked him where the rest of the drugs were, and he said that he didn't have any more. As I was asking, my co-defendant was checking his pockets, and my other co-defendant was checking his car. I asked again, and hearing the same response frustrated me, and I punched him in his face. He stumbled back on the car, and we walked away, and I got back into the car we came in and drove off. For 2 years of my incarceration, I kept asking myself, why did I throw that punch? If I had never punched him, he would be alive, and I wouldn't be here. But as time passed, I became more mature. I took a lot of programs, did a lot of self-reflecting, and built a steady routine of reading every day at 5 o'clock in the morning. Through all of this, I came to the realization. The question was no longer, why did I throw that punch, but why was I comfortable robbing people in the first place? That question caused me to look deeper into my life and see what caused me to arrive at that moment. I found traumas, insecurities, flaws, and weaknesses that I needed to work on. But one in particular was disrespect. I remember in high school, I got in trouble for fighting. And instead of them sending me to an alternative school, they decided to assign me to a program on the first floor where all of my classes were located in 2 rooms right across from each other to monitor me the entire day. One day, my teacher asked me to stay back after the bell rings to have a conversation. When class was over, he told me he heard about the fight I was in and said that I was able to release my anger and hit people legally without any consequences. I told him that I already know what he was going to say, and I'm not interested in boxing, but little did I know, he was also the head coach of the football team, and he told me I should try out. I told him I would think about it, and he handed me a card and said that today at 5 o'clock is the first day of trials. On my drive back from school, I kept looking at the card and told myself this could be a great opportunity for me and decided to go. My coach seen that I arrived and was happy that I came. He told me that we're going to start and introduced me to a senior by the name Malik and said that we're going to run routes and he needs me to guard him. I instantly said no. It was my first time and the whole school was on the bleachers watching me, and I didn't want to embarrass myself. My coach convinced me into doing it. We ran the route and I intercepted the ball. He looked at me and said, "Do you know what you just did? You intercepted the ball on my best wide receiver who has scholarships. You have potential, kid." Every day after school, I went to practice and played football. But during school, I couldn't get over the fact that people made fun of me for wearing outdated and dirty clothes. No matter how good I was at football, people still made fun of me, and that was the start of me deciding to go to the streets. I can't believe it was disrespect and people's perspective of me that derailed me off the right path. I chose to rob Gabe Bartle. I also chose to punch him, and I did it because I wanted people to respect me based on fear. I wanted a reputation as someone who's nothing to play with, so no one can make fun of me or disrespect me. But how ignorant and unenlightened was I? Because fear is no way to gain respect. I've been in the annex for 9 months, and every week I have to come to Cheshire to have a legal visit with my lawyer and social worker. Every time I walk throughout the hallways to go to the visiting room, correctional officers stop me to shake my hand and ask how I'm doing. They respect me, not because of fear or any negative reputation, but because I was known as a mentor in the TRUE program, an individual who helps others, takes his growth and development serious, and is a college student. These are the individuals I should seek respect from because they actually care about my well-being and not because of anything negative. None of this is a justification for what I did. I took a life, and I'm fully responsible. I said this to show that I understand where I went wrong and what caused me to make a horrible decision. There's a program called Voices that the Department of Corrections offers to help me understand who a victim is and the impact that my actions had on them. Voices helped me realize that Gabe Bartle wasn't the only victim of my actions. His family, friends, and community will forever be impacted as well. Voices helped me gain a deeper understanding of the impact of my actions on myself and others. I say a deeper understanding because I can only imagine how difficult life would be if I lost a son. I try to understand what you were feeling. I imagine losing someone very close to me, which is my mother. As know it's not the same, I will never completely understand the pain that you were going through, but I wanted to try to understand. The moment I began thinking about life without my mother, I quickly realized that it felt like a part of me was gone, and without that other part, I wasn't complete. I can only imagine how intensified that feeling is when losing a child. I thought about day-to-day life in your shoes and how it would affect your performance at work, as a parent, or even enjoying the moment and all the beautiful things that life has to offer. Thinking about parenting, I realized my actions can have a major impact on the children in the family that can't quite grasp the concept of death. These caretakers were traumatized by my actions. I was impulsive and inconsiderate, and what I did had a terrible and lasting impact. Through continuous contemplation of the situation, I understand the seriousness of my actions. I know that no matter what I do, I can never bring back your son. But that doesn't mean I can't do anything about it. I read a quote in a book that states, "The best apology is shown through action." Throughout my incarceration, I made sure that I took full advantage of my time by taking programs and reading books to change my way of thinking and developing new skills to make sure I never repeat the immature, inconsiderate, violent, and undereducated actions of my 16-year-old self. I was fortunate to be accepted into the TRUE program because after every program or book I read, I could engage in conversations with the mentors to deepen my understanding. I learned that I can and have changed my thinking patterns, habits, and character. I am no longer the individual I was, and I promise that I will continue on a path of growth and redemption. My life changed when I came to the TRUE program. I applied for the program when I was 18 years old. The application for the program required me to write a one-page essay explaining why I wanted to be in the program and what I could offer. I was fortunate to get accepted because when I told individuals within the program how much time I had, they said that they didn't usually accept brothers who are sentenced to more than 7 years. I knew that I was in a unique position. I was determined to take advantage of all that was offered. The program offered multiple programs, learning opportunities, mentors that we could speak to, and the time and space needed for change. I took advantage of each program that was offered to me and asked my mentors for help when I didn't quite understand what was being taught to me. The TRUE program is a 2-year program. Individuals who graduate have the privilege of choosing the facility they would like to get sent to. I realized I didn't have to wait until my release for a chance at redemption and give back to my community and society. I wanted to be a part of the process to help younger incarcerated individuals leave prison with a better mindset than they came in with, so they could be positive, productive members of society. To help them, like so many have helped me. So I asked to be a mentor. For so long, I have been part of the problem, but now I had an opportunity to be part of the solution. I know that I took a life, and nothing I do will bring them back. But teaching the younger individuals and guide them in the right direction is something I could do to make a difference. I was one of the youngest mentors ever in the TRUE program. I take pride in that because it shows how much I've grown throughout the years. Being the same age, if not younger than many mentees, makes me relatable. The information I share resonates with them. Seeing is believing, and seeing an individual that is around the same age as them who took the proper steps to change his life motivates them and shows them that it's possible to change theirs. It's possible to rise above any obstacle that confronts us. There's a quote that says, "You are not defined by your past mistakes." I make sure I tell mentees this quote daily because repetition causes permanence. There was a new mentee group that came in, and one of the individuals that was a part of the group was someone who had killed my best friend. Old feelings began to surface, but I'm no longer a part of nor abide by those street principles, rules, or codes. I know that the streets did us both a disservice, and it was my responsibility to prove to him that there was a better way. I called him to the back room and told him that I moved on and do not hold any grudges or hard feelings. He said the same. We shook hands and hugged. I realized that breaking the chain of neighborhood violence started with me. I began to facilitate programs for his group, which gave me the opportunity to share my journey with him. I wanted him to get the full experience that I got to help him change his life. I wanted him to realize that everything we were taught about the streets was all wrong. There's a better way. Eventually, I was signed to a group of 12 mentees. I was responsible for facilitating programs, running discussion groups, one-on-ones, and diffusing conflict. It was my responsibility to lead by example and show them how a man is supposed to always conduct themselves. I realized that being a mentor meant that my character was always on display. and this was another phase of my growth. I plan on going to a halfway house to help give me a smoother transition into society. It will provide me an opportunity to save money and help me acclimate to being in society. While I'm in the halfway house, I will open up a bank account, build my credit, get my permit and license, and take full advantage of all the resources they have that are available to me. When it's time to be released from the halfway house, I will search for an apartment that I could live in, which will be anywhere other than Danbury. Once released from the halfway house, I will purchase a vehicle to help me get to work and buy living necessities. I also want to find a therapist to help me process a lot of my trauma. Aside from a job, I want to enroll in college and take night classes because going to Wesleyan in prison was such a great experience, and that could be a positive community that I could be in when I'm home, and finish my associates and eventually get my bachelor's in psychology. I understand that returning into society is going to be a transition, and I will have to focus on myself for a while. I understand that times are going to be hard, and things might not always go as planned, but what I've learned is to overcome, be persistent, adapt to the circumstance, and make good choices consistent with great morals and character. I learned to apply these things in prison. I would like to give credit to the TRUE program and Department of Corrections. I feel prison was a blessing in disguise. Prison helped me to be the individual I am now. It forced me to do some self-reflection. It offered me programs that helped me understand who I was and who I want to be. It helped me see how wrong I was and educated me on the proper way to handle things and be a good person. I hope that you can see how remorseful I am, how hard I have worked at being a better person. I am very sorry for making decisions that not only took your son and loved one away, but also impacted so many lives of others. I'm so sorry.
Okay, thank you for your statement, Mr. Santana. In preparation for your hearing today, this panel's reviewed your file extensively, and the materials include the police report, your pre-sentence investigation, court transcripts, your records from the Department of Correction, to include programs, your education, disciplinary reports, evaluations from staff. We received letters of support for you and letters of opposition, and the summary of your interview with the parole officer. In addition, we received a memorandum from your attorney and social worker Hebeth. We're very well versed in your case. We do have some additional questions. When we're done with our questions, we'll ask the Office of Victim Services to facilitate victim input. We will hear from them, and then your attorney will have the opportunity to give a statement at the end. You'll get your decision from us here today. Do you have any questions?
No, ma'am. Thank you.
Okay. We'll begin with my colleague, Ms. Turner.
Mr. Santana, thank you for that opening statement. It was very well written and helpful, especially the part where you took us through your journey of understanding why this crime was committed. I had read at one point that you were under the influence at the time. Is that correct?
Yes.
Okay, so tell me some details.
At a young age, at 13 years old, I started to smoke marijuana, and I consistently smoked it almost every day to that day. The only thing I was under the influence was marijuana. I did have a problem with smoking weed.
I had read that you were also drinking.
Yes, I drunk very rarely though.
Okay, so alcohol wasn't involved in this crime?
No.
Okay. But you were having breakfast, you got an offer to smoke pot, you got in the car, there wasn't any, you were going to get it. So you being under the influence was what, the night before?
Marijuana? Yes. The night before I was smoking weed. I also woke up that day and I also smoked weed.
Okay, at home?
Yes, at home.
Before the pancakes?
Yes, I have a basement in my house that I would sneak down when my mother isn't around and I would smoke weed down there.
Who was making the pancakes?
My mother.
Okay. I'm sure it could be smelled throughout the house. It's pretty potent stuff. All right. You haven't taken a tier program, nothing through addiction services?
Yes, smart recovery.
Okay. So what did you learn in that program about drug use?
So that program actually has a twofold. One of them, they actually talk about substance abuse, and the other one actually shows you how you can have a good time without being under the influence. So there was like a system, a PlayStation, people played basketball, played baseball with football, and what they would do is they would teach us how alcohol or any type of drug use didn't need to be used to have fun. And I realized that me being incarcerated and educating myself and actually enjoying life, I didn't need to have any alcohol or marijuana in my system. And that marijuana is a gateway drug. I know I've always heard that as a kid, but I didn't quite understand it until they started teaching it to us. And what it is once you start inhaling marijuana, you start taking it, it's going to expose you to a variety of others.
Okay. So do you anticipate, now that marijuana is legal, resuming that use when you're back in the community?
Absolutely not. I don't want anything messing with my mental state. I realized that I've been very, very productive while incarcerated. I have a great habit, a daily habit of working out, reading, going to programs, and going to college. That wouldn't be a good idea to do that.
Do you see people there in the facility using K2?
Yes,
Pretty scary stuff.
absolutely.
Congratulations on getting your GED and 15 college credits.
Thank
That's
you.
That's real progress. It's impressive. I read about the other jobs that you had as in commissary and as a tierman, and recognize that you've gone 7 years without any disciplinary issues. You did accumulate 9 DRs, 8 of which were violent. What was going on for you when you were aggressive there in the facility?
At first, I was sentenced to felony murder before I went to manslaughter 1. And at 16 years old, I couldn't really grasp my mind around that. Yes, I was stressing. I was in a dark place. Just because I came to prison doesn't mean I learned anything. At the moment, I was surrounded by a lot of individuals that were younger than me, if not the same age, and we're all ignorant. You know, it's like the blind leading the blind. I was frustrated. I thought that if I put my hands on somebody and fight them, I think that was the answer for everything, as long as I would do that. But later on, I realized that's not the answer at all. And my last DR, I remember sitting in segregation and I told myself, is this how I want to do the rest of my time? Eventually, I will go home. Who do I want to be when I do go home?
Characters come up a couple of times, even in your opening statement. Can you describe your character for me?
Yes, disciplined, great morals, have a good moral compass, is steadfast to his principles, and I'm very spiritual.
So what are your principles?
So I changed a lot of my principles. They were negative when I came to prison. But now, for example, it's like I always make sure I educate myself. Education is a priority. Another principle is respect. As long as you treat people with respect, people are always going to treat you with respect too. But then there are some cases where if somebody does disrespect you, you do have de-escalation tactics. I remember a mentor told me, he said, imagine somebody arguing with a rock and the rock doesn't respond, of course, and you keep arguing with it. He said, who looks crazy in that instance? And I kind of thought about it. It is the person who's arguing with the rock. So as long as I'd never give anybody any energy or ammo to actually come at me and disrespect me, then I would never actually have to have that situation. I could always de-escalate it. But disrespect is one of them, and integrity. I'm very big on integrity. We play basketball. I don't care if somebody didn't see the ball go off my fingers. If it came out just as something as small as that, if it came off my hands, I'm going to tell the other team that it was off on me. If we're playing any card game, if we're playing chess and something happens, I'm always willing to take the high road.
What else does integrity mean to you?
It's doing something right when nobody's looking.
When's the last time you did that?
Last time I did that was in the TRUE program. So as a mentor, as a mentor, we have a big responsibility, and we're kind of in charge for a lot of mentees that are in the program. There could be up to 100, but I'm in control of 14 of them. The COs allow us to run the block. So what I did was, even when the COs aren't there and we're playing basketball, what I actually do is if they actually come in and tell us, has anything happened or is there anything wrong with the situation, I will always tell them exactly what happened. Yes, this individual argued, this individual said this, and I make sure that I bring them to a common ground and we actually have a conflict circle and we actually try to diffuse the conflict with a bunch of skills that we learned. So regardless if somebody is looking or not, I'm always going to bring them forth and we're always going to correct the situation. Nothing's going to get swept under the rug.
So I'm hearing honesty and truthfulness. That goes towards your moral compass. What else would you say your moral compass is comprised of?
So yes, I mentioned respect, but also when it comes to a moral compass is love. Love could be another part of that. I'm big on love, treating people with love.
Anything else guide you?
I mean, guides me, yes. I've read a lot of books, a lot of autobiographies. One of them, of course, is Malcolm X. He educated himself in prison. We all actually read that book while I was in Wesleyan too. That was a great book. It actually guided me. But I realized that when I read these authors, one thing about them is they actually are very, very steadfast to their principles. They're disciplined. They're always educating themselves. And they don't surround themselves around individuals that are not like-minded.
I read about conversation circles. Is that, that's a program you developed?
Yes.
Okay, do I have the title right? Conversation circle?
Yes.
Okay, so you'd sit together and talk about one topic for an hour?
Yes.
Okay, so give me some examples of what the topics that have been brought to the group were.
Okay. One of them is loyalty. I feel like people have a misconception of what loyalty is. A lot of people in the streets think that loyalty means that if I'm with somebody and something happens to me, they have to jump in and beat this person up. And that's considered loyalty. Or you go home and you don't have anything and they want to give you a gun or drugs and they say that's loyalty. And I would actually be the person to tell them that that's actually wrong. And I would show them that that's not love. If somebody actually cared about you and loved you and actually wanted to show loyalty, it would not be putting something in your hands that will lead you back to prison. What it would be is give you job opportunities, show you equality, give you maybe money to help you. And then if nothing goes on with that after the money I gave you and you decided to spend it on anything negative, then that's on you. But a lot of people have that misconception, and believe it or not, the topic will actually go on for maybe longer than an hour because people are always going against me and some people agree, and then they'll actually have their own conversations and people would chime in and it would just be a huge conversation.
Do you tie the concept of loyalty to one's moral compass?
Yes.
Because you have to be loyal to yourself first and not be thrown off your compass, right? By negative influences.
Absolutely.
So how do you think that played out in your crime?
I wasn't loyal to myself. I was living up to an image. I cared too much about what other people thought. I cared about their advice, who they were, and their loyalty to me. That's what I cared about. And it was wrong.
It's hard to be judged. You experienced that in terms of some of the material items you didn't have. And then were ridiculed for that. So the idea of fitting in and having an established position among your peers was part of your internal motivation in the way you were living your life. Do I have that right? Does that sound?
Yes.
you know, we talked to a lot of men your age and younger at parole hearings, and I've seen far too frequently people die as a result of a blow to the head. Sometimes they fall and then they get punched, they fall, they hit their head on a curb. In this case, there was a process, it seemed like the victim went through of being stunned, complied with your all's demands, and fell down to the ground, whether he first got in a sitting position himself or, you know, as the brain bleed took over his, and he slipped into unconsciousness. There was no effort by you and your co-defendants to render any aid. And there was a little bit of conflicting comments in the interviews with law enforcement about what was seen after you punched the victim. What can you tell me about that?
I was so wrong for what I did. I understand I took a life. I did. I'm fully responsible for that. Whether it was a punch or not, he lost his life. I wish, I tell myself this all the time, I wish that I did know that that was going on. At the moment, I didn't know that there was internal bleeding, that there was even a possibility that somebody could die over a punch. And when I actually sit with that and I realize that, that's why you have to de-escalate situations. It doesn't matter what the situation is.
Not
Anybody
worth it.
could, absolutely, it wasn't worth it at all.
Uh-huh. It's interesting that you use the phrase that the victim lost his life. It sounds like a way of distancing responsibility for the fact that your actions cost him his life. You took it from him because the medical emergency that ensued. But my question earlier was about rendering aid. Nobody did anything, and then for the family members to know that he died alone in the street, left alone, compounds their grief. Was there any consideration for getting him help?
No.
What do you know about the victim?
Just a little bit. I've heard about him.
He was extraordinary. At 18 years old, he was a docent. Do you know what that is?
No, ma'am.
He worked at the Aldridge Art Museum in Ridgefield, taking people through the museum and explaining to them the exhibits. And he also taught cartooning classes at 18. I mean, what 18-year-old can you get to go into a museum, let alone sign up to play a role in helping visitors appreciate what the museum has to offer? I mean, that's extraordinary, don't you think?
Yes.
Yeah. And I read a couple of places where when he got his driver's license, it wasn't about the freedom and the independence of being a licensed driver. He got to show people he was an organ donor. That's what mattered to him. And in death, he was, which has given the family some measure of consolation, though I doubt it outweighs the idea that their loved one died alone laying in a street with no one to render any aid, except a passerby who happened to be an EMT. So just such a tragedy. So the family, I assume, had some input at your sentence modification. You were seeking to have your sentence reduced by 3 years. And you were afforded 1 year, which I understand you felt pretty grateful for.
Yes,
Your co-defendant who pled guilty got a 9-year sentence, right?
yes,
For conspiracy. So were you to be granted discretionary parole today, that would be at that 9-year mark. And you do realize, I'm sure, because it was said over and over again at sentencing, that the judge took into consideration all the information about brain science, problem solving, reasoning, impulse control, and everything. And that's why you only got a 15-year sentence for taking the life of another person with only 12 to serve, and now it's 11. And what we're talking about here today is bringing it down to 9. What do you think the family's experience is? These are legitimate opportunities you were afforded to have your sentence reconsidered. But what do you think the family's experience is of these, what must feel like to them, these constant contacts by the criminal justice system to say, hey, here's another opportunity for input because we're considering lowering his sentence even further?
it has to be painful. Feels like probably ripping off a Band-Aid off an injury that quite isn't healing yet, and you just keep ripping it off and ripping it off.
I would also imagine they feel pretty angry, pretty let down by the criminal justice system. 15 years, I read in their statements at sentencing, they were looking for you to serve a much more significant period of time.
Yes.
And it's re-traumatizing every time it comes back up, or the trauma is just sort of low grade and it just is stirred. I did read that you felt your sentence was fair, and as I said earlier, that you were glad to get the 1 year, which is in recognition for the work that you're doing there in the facility, your own efforts at rehabilitation. You've overcome a lot, Mr. Santana, with, a very challenging childhood. I'm glad that you're invested in your education and you see that as an avenue to develop the rest of your life. But this was tragic all the way around. Thank you for talking with me. Thank you, Madam Chair. Mr. Rodriguez.
Okay. Mr. Santana, you had a reputation when you were younger and you were known for fighting. Can you tell us where this anger came from and why you were so aggressive?
I don't like to use this as an excuse, but this is what I feel. I didn't grow up with my dad. Right there, I was always mad. I always came out of school and my mom would pick us up and I would see other students get picked up by their father. I always wanted my dad, and he was incarcerated for 15 years. I never had my dad. On top of that, my household, I used to watch my mom come home, and she was a waitress. And I feel like as a 9-year-old kid, until up to 15, you shouldn't see your mom come home screaming, yelling how she can't pay the bills. At that age, I'm not supposed to process that. I'm not supposed to see that. I was angry. I just felt like the world was kind of just treating me a certain way.
Did you witness a lot of violence?
Yes.
Can you elaborate?
My mom, she had a lot of people that would come in the house. She was with a lot of men, and a lot of them would abuse her physically. So there's a lot of times where I see my mom get beat up a couple times.
What are your relationships with your family members now?
The only person I have a good relationship with is my mom. My family from my dad's side, I really don't know them. And then my family from my mother's side, they don't really accept me because of my situation.
Okay, so who are your biggest supporters other than your mom?
I have a friend. She's a woman. She known me since I was a kid, and she's been really supporting me along the way.
Yeah, we did read about her. You also have a lot of general support in the community from previously incarcerated individuals who are doing well, right? And in academia. Why did you leave Wesleyan?
I transferred.
Okay, so you couldn't stay in the program.
Correct.
Okay, but that the program is still open for you. Should you return to the community?
Wesleyan?
Yeah.
Absolutely.
Can you go back? Yeah. Okay. So you would have a scholarship to attend college in the community?
Yes, it would be Middlesex.
Mm-hmm. Okay. I did read about some mentoring over Zoom with MYI inmates. Are you still involved in that?
No, so when I transferred from Cheshire, I went to Cybosky, the second chance program. I went from one program to the next for work opportunity. And there I also continued college. I went to Asanuntuck, and they had a program every Tuesday and Thursday to mentor younger individuals. I was already a mentor in the TRUE program, so I just fit right in.
Okay. How long did you do that for?
11 months.
And how long were the sessions over Zoom?
An hour.
And what did you talk about during those sessions?
So there's a counselor from MY, Men's and Youth, that actually runs the program. So before the younger individuals would arrive, she would tell us the concepts that she wanted us to build on. So some of it would be on credit, financial literacy, how to reintegrate back into society, and most importantly, how to do your prison time as a productive member, right? As a model inmate.
And what kind of work are you doing now? What are you doing in your current position?
Lobby work. I'm a lobby cleaner.
A cleaner, okay.
Yes.
And that is that in the annex?
Yes, ma'am.
Okay. You did get excellent evaluations from the staff in the facilities in the TRUE program and the other jobs that you've held over the years, and actually recommendations from staff members for your release. I, like my colleague, I share your story or something similar quite often. Whenever I read about someone getting into a fight or assaulting others, because the truth is, not enough people know that one punch to the head can kill someone. You know, it's so common to hear about fighting, especially in the younger population, that I think word really does need to get out there. You have no idea what kind of power you have when you hit somebody. So tell me what you plan to do to give back to your community in the future.
So I started off with Wesleyan. I do want to get to Middlesex. That'd be a great community that I can involve myself. Like-minded individuals, but I also want to find a program that I could get into where I can also mentor, free of charge. I just want to tell individuals my story, help educate them, hopefully change their perspective. But I don't know any programs right now currently, but when I am released, I will try to search. And I think that'd be a great thing that I could do. It could be like a new hobby, kind of the similar like I did in the TRUE program when I was mentoring and running programs.
Okay. And what are your plans for work?
Currently, I have no plans. I think that I hear this a lot. A lot of individuals have a problem with getting a McDonald's job, a job that pays them $16 an hour. I have no problem with that. I understand that I have to start somewhere, and I'm going to work hard to try to earn a position, like maybe a manager position somewhere, but I'm willing to work anywhere for the time being until I can actually experience my full opportunities.
Okay. And what are your long-term goals?
I want to be an entrepreneur. I do want to get my bachelor's. I want to continue going to college. That was a great experience for me. I do want to have a home. I want to buy my own house and a vehicle. But most importantly, I want to build a great community around me. I feel like a lot of people don't understand how important your community is, the people you surround yourself around. The True program really saved my life. It really opened up my eyes, and it showed me how surrounding yourself around mentors and like-minded individuals could really influence you and impact you in a positive way.
How long were you in the True program?
Almost 7 years.
And how long were you a mentor?
3.
You're still very young, Mr. Santana. At 25 years old, it's hard to imagine that you took someone's life and you could be back out there. Do you think your brain's fully developed now?
Based on the science, it says yes. But me personally, based on everything I've been doing, I would say so. I put in a lot of hard work to try to change my way of thinking.
Do you recall the last time you were angry and how you handled it?
Absolutely.
Go ahead.
So when I went to Cybulski, I like playing chess. I'm an intellect, right? I love using my intellect, very intellectual. So there's an older guy by the name of Mike Nice. He's one of the greatest chess players I probably played. I told myself that I want to play chess to work on my decision-making, on my reasoning, but also to control my emotions. So I'm a big advocate of controlling your emotions. I created a program called Emotional Intelligence. So as I'm playing chess, he would win 50-1, and my ears would get red. I would get really upset, but I still shook his hand at the end of the game. And I realized, I have a book that talks about chess, and I realized that you can't allow your emotions to override your decision-making. Your whole chess game will just fall apart. So at that moment, I never allowed myself to ever get out of character. I always shook his hand, always smiled and laughed, and always came back to want to play a game. And I remember he told me, say, you know what, man, for a young dude like you, you never cursed at me, you never yelled, you just always shook my hand and continually kept playing chess. And he actually made me a good chess player. Right now, I'm actually one of the best in the prison I'm at right now.
Okay, I missed the part where you got angry.
I got angry when he would win all the time. Every time he would beat me, I would get upset. But I didn't allow that to piss me off.
Okay, since your last ticket was 7 years ago, since then, have you ever had arguments with any inmate? Has anyone ever tried to fight you?
Yes.
Okay, and how do you handle that?
So I took conflict resolution skills, and one of the main important thing about it is effective communication, being clear, learning how to de-escalate it. So it's using like I statements, right? Not getting upset when you're talking, like your tone of voice, and be able to ask the person, what did I do to make you feel a certain way? So there are a lot of people who, like, if we get on the basketball court, people will start cursing. They got in my face. But the first thing I always realize is I always tell them, like, it's a game. Like, hold up, fellas, let's put a pause to this real quick. We're not here to fight. I'm here to play basketball. And then we would have a conversation and we would move on. But I never allow it to be a thing where I'm always going to curse back at the individual. I'm always going to try my best to de-escalate it. And if the individual doesn't want to talk, I always walked away, always. And because it's the True program, I always go and visit their cell later because I'm a mentor. And 9 times out of 10, I would automatically apologize if I ever made them feel some type of way. And then we would have a conversation about it and we would correct it.
Okay. What happened in your last fighting ticket in 2019?
So that was my best friend who passed away. And this is the childlike mentality. I'm so happy I matured, but just thinking back, why are we horse playing in a cell? I ask myself that all the time. We were horse playing, we were bored, we were young, and he hit me in my face and I ended up getting a mark. And the warden came by and seen me and she asked me what happened. And I told her not to send me to SEG, but she said she had a job to do and still send me to SEG. So I went to SEG.
We'll forget that one. How about the December 2018 fight? What was that about?
I don't remember. Does it say anything else? Like something that could help me with my memory?
No, but you've had quite a few. So give me another instance. You've had quite a few fighting tickets, 2018. Just pick one. Tell me about the scenario. What happened?
Okay, so one I remember. I was in a unit. Individuals from a different town came inside our unit, and they said that somebody had disrespected them. I was still head over reputation. I still wanted to be about reputation and prove to these guys that I'm somebody. And when they called school call, I told them that I'm going to punch this individual. And when we got out there, I seen him and I punched him. I went to SAG
Okay, where'd you punch him?
in the head.
Okay, so you still hadn't learned that one punch to the head could kill someone.
At the
Yeah.
time, no.
Right. Well, I appreciate your honesty. Okay, you're asking to go to a halfway house?
Yes.
All right, so if you had to choose something that you're still working on, tell us, what would that be?
Something I'm still working on. I would
Yes.
say emotions still. Feel
Yeah,
like
well,
that's
I
a-
would imagine that's an ongoing, maybe not challenge, but yeah, that's a process. Okay. All right, so at this time, I think we're done with our questions. We're going to ask the Office of Victim Services to facilitate input, okay? You can listen, please don't interrupt. Ms. Vasquez, thank you for joining us.
Thank you, Madam Chair and board members. I had the opportunity of speaking with several members of the victim's family, and they have asked me to read these statements on their behalf. Good morning, board members. My name is Anna Vera, and I am Gabriel's mother. Losing a child is the worst thing that can happen to a parent. There are no words that can truly describe the pain, heartbreak, and devastation that our family has endured since Gabriel was murdered. Gabriel was the kindest person I knew. One of the first things he said to me after getting his driver's license was, "Mom, I'm an organ donor." Even as he was losing his life, Gabriel continued to give. Gabriel saved 6 lives by checking off that donor box. That simple act reflects the kind of person he was: selfless, caring, and always thinking of others. No words can ever fully express the pain that his death has caused, not only for me, but for our entire family. Gabriel's brother and sister were robbed of many years they should have had with him. They both suffered severe panic disorders after his death. It took years of psychiatrists, therapists, doctors, medications, and treatment just to bring their panic attacks under some level of control. There were days and even months when Gabriel's brother could not leave the house. I had to leave work countless times to pick up my children from school because of panic attacks and emotional breakdowns. There were doctor's appointments, therapy sessions, medications, and the overwhelming financial stress that came with trying to help my children heal while being emotionally bankrupt myself, trying to keep our lives together and still being there for my children. The effects of Gabriel's murder did not end on the day he died. They continue to affect us every single day. I have been in therapy since Gabriel's death and continue therapy to this day. I watched Gabriel's friends get married, build careers, and have children of their own. Every milestone I see reminds me of the life that was stolen from my son. I know that I will never experience those moments with Gabriel. I will never watch him get married. I will never meet his children. I will never have the opportunity to see the future that was taken from him and from our family. I wake up every morning with a broken heart. I am not the same person I was before Gabriel was murdered. The images from those final days will forever be burned into my head. The sight of my son lying in a hospital bed, lying next to him, feeling his lifeless body, connected to life support for 3 days. So is the image of him being left on the side of the road to die alone. Lorenzo left Gabriel to die. No one went back to check up on him. They had even stolen the shoes off his feet. Those memories, they never leave me. I would also ask everyone making the decision about Lorenzo's parole to remember that every year Gabriel has been gone is another year that our family has had to endure this pain. While incarcerated, Lorenzo has had the opportunities that my son never will. Gabriel lost his life, and we lost a future with him. At the time of sentencing, Lorenzo's young age and level of development were considered by the court. Gabriel's age, however, was never allowed to continue developing because his life was taken from him. Lorenzo still has the opportunity to build a life. He can marry, he can have children, he can create memories and experience milestones. Those are opportunities that he took away from my son forever. No amount of time served can bring Gabriel back. No amount of rehabilitation can restore what was taken from our family. I respectfully ask that parole be denied. The pain, trauma, and loss inflicted in our family have been lifelong and irreversible. Gabriel deserved the chance to live his life. He deserved the opportunity to grow older, build a future, and fulfill his dreams. Instead, he was taken from us at just 18 years old. We will carry that loss for the rest of our lives. Thank you for allowing me to share the impact that Gabriel's murder has had in our family. Anna Barra, mother of Gabriel. I'm going to read one more statement.
Thank you.
Dear Parole Board, I submit this statement to express the lasting harm caused by this crime. The death of my brother Gabe has caused major impact to my family. My mom doesn't get to see her firstborn child grow up, get married, have kids, or continue his love for music. Instead, the closest she can get to him is her necklace filled with Gabe's ashes. Every holiday is filled with grief as we wish and pray that Gabe can spend it with us. On Gabe's birthday, we didn't get to see him blow out the candles. Instead, my whole family gathers at the cemetery and writes messages on balloons to send to him. My family lives in grief, praying to get Gabe back. For these reasons, I respectfully urge that the defendant remains in custody to ensure that this cruel act doesn't happen to another family. Thank you for your time. J.B., sister of Gabe. Thank you, board members. This is all that I have for this case.
Thank you.
At this time, we will turn it over to Attorney Veladata. Do you wish to proceed?
Yes, thank you. Good morning. Mr. Santana has never given up an opportunity to take responsibility for the events that transpired on August 5th, 2017. I know this board had inquired into Mr. Santana as to whether he had gone back to render any aid to Mr. Bardo. It is evident in Mr. Santana's affect and demeanor this morning that he sticks by what he had initially said to this board and has written on many occasions, that he was blinded by peer pressure and making a name for himself in the street. And additionally, it is clearly evident that he not only regrets the actions that resulted in his death, but also any omissions and failure to act subsequent to it. And in many ways, he's expressed his remorse, regret, and apologies to the family and society as a whole. What is most notable of Mr. Santana's acknowledgement is his recitation of a quote that he read in a book that states, "The best apology is shown through action." Mr. Santana has shown through his actions an exuberant amount of change. He presents today with an impressive record of rehabilitative efforts. His desire for change is never ending. Although he will relive August 5th, 2017 and recognizes that the family will do the same, he knows that there's more life to live, a life that should be lived by abiding by the laws, caring for others, and engaging in productive and efficient daily activities that advances the public good. Mr. Santana has never blamed others or spoken negatively about Mr. Bardo or his family. He has remained steadfast in addressing the root causes of his behavior that led to the crime-filled childhood and teenage years. It should resonate with this board that the commitment Mr. Santana has made to maintain accountability and remorsefulness. His focus has always been in the right place since the day he accepted responsibility on August 18, 2018. Mr. Santana will have served 85% of his sentence in December of this year, and we are of the opinion that continued incarceration will neither benefit Mr. Santana nor society. He has utilized all that the Connecticut Department of Corrections has to offer and has taken full advantage of programming that is aimed at rehabilitation, education, and personal well-being, strength, and betterment. Specifically, Mr. Santana engaged in the Voices program, during which he was in tune with the feelings and thoughts of Mr. Bartle's family. Program, he was able to see things from the victim's perspective and caused him to sympathize and fully understand the seriousness of the situation. Additionally, he has taken the initiative to be a mentor in the TRUE program, where he utilizes his personal experience to educate others and to allow them to gain insight into their thoughts and actions to be better versions of themselves. Mr. Santana's utilization of those tools he learned while incarcerated will not stop when he is released. These tools will stick with him and be present in his everyday life for the rest of his life. Mr. Santana asks his board to give him the opportunity to prove that his efforts at rehabilitation while incarcerated will fare not only him well, but society as well. Mr. Santana will remain committed to seeking ways to better his life and to help those around him. He will devote his life to productivity and refrain from engaging in his old ways. This is especially evident in his lack of a ticket in DOC in 7 years. To reiterate what this board knows, Mr. Santana attributes his ticket-free behavior to having a mentor, something that he will never forget and something that he aspires to continue to be in the future. Mr. Santana is an excellent candidate for parole, and he respectfully asks this board to agree. Thank you.
Okay, thank you. This time the panel will enter into deliberation. Mr. Santana, you can listen to our deliberation and we'll come back to you shortly with our decision. Okay, Ms. Turner.
So this is just a tragic situation, both for the victim whose life ended at age 18, and for Mr. Santana, who sits before us incarcerated. I recognize and appreciate the work that he's done on himself. So, you know, it's sort of the 3 legs of the stool that I look at: education, holding down a job, and programming. And perhaps he even deserves a 4th leg of mentoring. It's all incredibly positive. And, you know, his insights into himself at the time and his aspirations of wanting more and better for himself in the future are to be commended. Where I struggle is, you know, 11 years to serve for taking a life. He is eligible in December. It would be in a year and a half in discretionary parole. He has 2 years left on this sentence, 2 years this month. And the impetus behind 1584 with brain science was thoroughly addressed at sentencing and readdressed with the sentence modification with a whole passage acknowledging that the judge initially in setting 12 years understood the impulsive nature with frontal lobe development, etc. So they were willing to give him a year off the 12 for an 11 years to serve part of his sentence. And that's where I stand. I'm comfortable with the sentence that he has, and out of respect for the harm and lasting grief that the family's experiencing, my vote is to deny.
Okay, and I do want to thank the family members for providing statements to the Office of Victim Services. We appreciate your input. Understand this must be so difficult. So, you know, I try not to get too involved in the judicial process because we don't really have all the information. I understand that part of the reason there was a plea bargain here is because there was some concern that, you know, should he go to trial, he might not be found guilty. But we're not privy to all of that information. And while I do understand, we did read about how his age and the circumstances were taken into consideration. We are a separate process, and the Public Act does ask us to look at these situations again, and specifically to look at rehabilitation and the probability that one could remain in the community and not commit more crimes, and the benefits of incarceration versus release. Certainly, this is a tragedy, and it is a life sentence for a loss of life, but I believe in this case, a very impulsive and reckless decision led to this loss of life. As I said earlier, I think not many people consider the harm that they can do with just one punch. And what followed certainly was childish behavior, leaving the scene and not rendering aid and not making sure that the victim was okay. Very childish behavior. He was 16 years old at the time. But Mr. Santana's done a lot of work since then by way of programming, education, as you said, mentoring, working. And while he's still young, I do believe that he has changed over the last 9 years. And I think there is a reasonable probability that he could go out there, continue to educate himself, find a job, and build a positive life for himself. More importantly, give back and spread the message in the community that still deals with these issues every day. I believe that 1.5 years of supervision under parole would be beneficial to him and to the communities in ensuring that he is successful. He almost needs the wraparound services, and he does have the support of others who were formerly incarcerated and who have turned their lives around. My vote today would be to grant parole. Mr. Rodriguez.
Thank you, Chair. It's a very difficult case. I'm going to acknowledge the victim's case. I do have a very empathetic and very understanding of the loss of a child with a basic understanding. For me, I do believe I've seen change in Mr. Santana. He's completed his program. He's worked through the TRUE program. He's mentored the program. He's facilitated groups. He started his own programming. He acknowledged what he wants to do when he gets out. His release plan for me sounded plausible and workable for him. And he kind of laid it out for us what he wanted to do and how he wanted to do it. I'm going to be supporting his discretion vote today as well, because I do think that the supervision for 1.5 years remaining, I think, would be very important for him to help him get back on his feet. And that not understanding the loss of his family.
Yeah.
That's a very good understanding of that.
Yeah.
I'm going to be supporting his discretion for those reasons. I do see some growth in it. And I do think that with that support, he might be able to really out the community, maybe even help somebody not to make this kind of impulsive, foolish mistake again.
Okay, I have a bunch of names and family members of the victim, and then we have co-defendants in a halfway house. Yeah. Anything further? Okay. All right, in the matter of Lorenzo Santana, inmate number 422119, I'll make a motion to grant parole effective December 26, 2026, with the following additional conditions. You're to have no contact with the family members of the victim. Initials are NB, BB, AG, AB, LB, JB. Those are the names that I have. Excuse me. Sneeze. Thank you. You'll be placed in a halfway house, and you're not to have contact with your co-defendants, Ronald Masagli, Jason Cuchimbo, or Miranda Nugent. Is there a second to the motion?
Second.
All in favor? Aye. Opposed? Aye. This is a majority decision with Board Member Turner dissenting. Thank you to everyone for your participation. Mr. Santana, do you have any questions?
No, thank you.
Continue on this positive path and do everything that you can to give back, please.
Yes.
This concludes the parole hearing for Lorenzo Santana, inmate number 422119. It also concludes the chapter 23169 hearing. It is 11:48 a.m.
Yes.
Thank you. So we're going to go. Sit and for yourself for the record. June 15th, 2020. Okay, Mr. Holly, we're going to get started, okay?
Okay.
All right, so good morning. I'm Parole Officer Trisella, and I'm hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Montrell Holly, inmate number 371458. Today is Monday, June 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Cheshire Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Montrell Lee Holly, 371458.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Holly.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Hawley, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for today's hearing. First, I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
We will now review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So on charge number 1, the condition of obedience to the law, the charging officer reported that on 2/17/26, you assaulted another parolee at the January Center by punching him in the head multiple times. Based on your actions, you were arrested by Troop E and charged with Connecticut General Statute 53A-61, assault third, and Connecticut General Statute 53A-182, disorderly conduct. This is evidenced by Exhibits E and M. On charge number 2, the condition of probable sexual behavior treatment, the charging officer reported that on 2/17/26, you assaulted another parolee at the January Center, which led to a criminal arrest for Connecticut General Statute 53A-61, assault third, and Connecticut General Statute 53A-182, disorderly conduct. Your behavior violated multiple program rules and regulations at the January Center. You agreed to these rules and regulations for the program when you signed the January Center program participation form on 10/16/25. And you also signed the January Center Resident Handbook Acknowledgement Form on 12/30/25. Based on your actions, you were negatively discharged from the program for your assaultive behavior. This is evidenced by Exhibits E, F, G, H, I, and M. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the assigned conditions of release, Exhibit B, the remand to custody, Exhibit C, the parole violation report, Exhibit D, the notice of parole violation / parolee rights, Exhibit E, the police report, Exhibit F, the connection discharge summary report, Exhibit G, the January Center program participation, Exhibit H, the January Center resident handbook, Exhibit I, the resident handbook acknowledgement, Exhibit J, the State of Connecticut Board of Pardons and Parole's decision information summary, Exhibit K, the State of Connecticut Board of Pardons and Parole's written decision form, Exhibit L, the State of Connecticut Board of Pardons and Parole's hearing disposition, and Exhibit M, the January Center camera video from hallway. In addition, the state did file an addendum to the parole violation report on May 20th that states that on May 14th, Mr. Hawley received the disposition under docket ending in 622S and was guilty of assault third, received a 60-day jail sentence, and the disorderly conduct was nollied. Mr. Hawley also received 4 Class A DRs since he was remanded. The subject received an assault on 3/3/26, refusing housing on 3/15/26, fighting on 3/25/26, and fighting on 5/6/26. The disciplinary reports were submitted and attached. Those will be identified as state's exhibits. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today? Yes, sorry. And I did receive an exhibit from the defense. I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Council, do you need to any time submit any other documents?
We do not, thank you.
And we don't have any witnesses. So it is now the defense's opportunity to present evidence and speak to the evidence submitted. So counsel?
Yes, just very briefly as to the charges. I would just note that the addendum as stated was accurate. My client received 60 days to serve on one misdemeanor assault third charge. All other pending charges were nollie, and his EOS date on that new 60-day sentence has passed as of May 14th, 2026. I will note as to charge 2, I would just like to indicate that there were no allegations here that my client wasn't engaged in treatment while the program. My understanding is that he was actively participating in the treatment there. And we would at the appropriate time like to speak to his background and history. Thank you.
Thank you. So I am going to announce my findings, Mr. Hawley. On charge number 1, I am going to find that you violated the condition of obedience to the law based on that conviction of assault third when you received a 60-day jail sentence. In addition, the evidence in support of that charge is states exhibits A, C, E, F, and N. I also find that you violated the condition of problem sexual behavior treatment based on the evidence presented in states exhibits A, C, E, F, G, H, I, and N. So it does conclude the fact-finding portion. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I'll recommend. So counsel?
Yes, thank you. My client's 39 years old, born and raised in the Middletown, Connecticut area. He does have a large support system in the community, including his grandmother, his several siblings, and his cousins. My client also has 3 kids, ages 18, 15, and 7. Upon release to special parole in December, my client was placed at the January Center where he remained until remand. He does have an employment history that includes customer service work, plastic injection and molding, landscaping, warehouse and factory work, and food service. His last full-time position was at Wendy's in Cromwell, Connecticut. While at January Center, my client was actively participating in the CTPSB program. He reports undergoing a reconstructive knee surgery in December of last year, and as a result, is in need of physical therapy for that. This is his first violation of special parole. Upon reinstatement, he would like to successfully complete the January Center and then be sponsored by his grandmother at the provided residence we gave in Middletown. He is interested in going back to school to study business management and finance one day. He does report having a job opportunity with a friend of his who owns a stone company out of Norwalk, Connecticut, for when he is released back to the community. He is open to any sort of treatment, including successfully completing the CTPSB program, and is very much anxious to establish primary care services in the community to tend to his medical needs. He is also interested in participating in community service in his free time. I am asking that you would consider re-paroling Mr. Hawley on the first available board review date. This is his first special parole violation. As we noted, his EOS date on the new sentence has passed, and he has been incarcerated at this time for over 4 months. Mr. Hawley, is there anything I didn't include that you want to say at this time?
No.
All right, thank you very much.
Thank you. I'm going to take a moment, then I'll announce my recommendation. So I do need to, I want to note some things on the record, Mr. Hawley. I know that this is your first violation. However, it's a criminal violation and it's a violent criminal violation. So that's concerning. And you were only on supervision for approximately 1.5 months between your release and when you were remanded into custody. In addition, you did receive a new jail sentence for that assault third of 60 days, and Parole and Community Services has recommended a 6-month sanction. However, that was before you've received 3 violent DRs while incarcerated. So the behavior is just really concerning to me, Mr. Hawley. With that, I'm going to recommend your parole be revoked and that you serve an approximate 9-month period of confinement as a sanction. That's with the re-parole date of November 17, 2026. I do just want to note on the record, I am taking into consider those 3 DRs that you received that were listed in the addendum from Parole and Community Services, the 1 assault and 2 fighting tickets. I'm going to recommend the following conditions: no consumption of alcoholic beverages, behavioral management program for anger management and domestic violence, no contact with victims LL and KT, mental health evaluation and treatment as deemed necessary, and problem sexual behavior treatment and halfway house placement. So what happens next, Mr. Holly, is my recommendation is going to go to the board on June 25th. On that day, the board can do three things. They can adopt my recommendation if they choose to do so. They can lessen it if they choose to do so. So they can pick any day between June 25th and November 17th. And then if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back for another hearing to address their questions and concerns before anything longer is imposed. So that does conclude today's hearing. Do you have any questions?
It was more of a statement. The DRs are really because of my charges. Like when I'm in GP and when I'm moving around, people don't like respond to me socially. And so that's just like me protecting myself.
I'm gonna note that, Mr. Holly, but I just want to also let you know though, the recommendation date can also be changed in the future. So I know that you're saying that you're defending yourself, but if you catch more DRs, whatever the board decides on a date, we can also rescind that voted to parole date. So just be mindful that none of this is ever set in stone. Your behavior and there does unfortunately follow you, I guess is the right word. So whatever the board decides on the 25th, if you're there to stay till November and you catch 2 more fighting tickets, you're going to be back in front of the board for a rescission hearing. So you got to try to, I don't know, walk away. I'm not sure, but does that make sense?
I understand what you're saying. Mr. Holly, I'll set up a legal call with you so that we can kind of debrief everything and discuss, and I can answer any questions you might have at that point, okay?
Okay.
All right, thank you.
This concludes the revocation hearing for Marshall Holly, inmate number 371458. All right, good luck to you, Mr. Holly.
Thank you.
Thank you.
Yeah, man.
As soon as he come out, you can go right in, but you have a seat right there.
To it, huh?
Good morning.
Good morning, Mr. Brooks, right?
Yes, ma'am, how you doing?
Good, how are you?
I'm all right.
All right, we're gonna get started, okay?
Yes, ma'am.
All right, so good morning, I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Shalik Brooks, inmate number 341751. Today is Monday, June 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Shalik Brooks. My number is 341751.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Sure. Attorney Alfonso Sirico from the Parole Revocation Unit, on behalf of Mr. Brooks.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Brooks, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes, ma'am.
Thank you. So we're going to go over the procedure for today. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
We'll now review the charge that the state, your parole officer, is bringing against you and the information underlying that charge. So charge number 1, the condition of obedience to the law, the charging officer reported that on 12/24/25 at approximately 11 p.m., Manchester Police stated you were involved in a domestic violence incident. Per the report, you had a verbal altercation with the victim in front of several children. Subsequently, the police came and you were charged with disorderly conduct and 5 counts of risk of injury to a child. The evidence submitted was already identified at the preliminary hearing, and that all does remain the same. In addition, the state did file an addendum to the parole violation report on May 19th, and that states that both charges were disposed of on May 15th. The disorderly conduct or all the charges, disorderly conduct and the 5 counts of risk of injury to a child were all nollied. Counsel, to confirm you and your client did receive the notice of parole violation, the parole violation report, and all the other documents listed.
Yes.
I did receive 2 exhibits from the defense.
Yes.
3?
2.
2.
It was only 2. Well, 3 has 2 pages, I think. What I want.
So exhibit 3 and 2. I think that should be a 1.
Yeah.
That's
It's just the affidavit, yes.
So exhibit 1 is a list of parole accomplishments and future plans for parole reinstatement, and exhibit 2 is the affidavit from Daquana Bulk. Blake. It's Blake, right? Blake dated 1/12/2026. Counsel, do you need time to submit any other documents? No. And we don't have any witnesses. So at this time, it is the defense's opportunity to present evidence and speak to the evidence submitted. So counsel?
Yes, on behalf of Mr. Brooks, so we can see here that it's a singular charge of obedience to the law. All of the charges in court were nollied. And I also spoke to Mr. Brooks in early part of June. He was advised that this case, because it was a singular charge of obedience to the law and all the charges were nollied, it appears the case was reviewed for a warrant withdrawal from PCS. And it looks like that, obviously that was denied and he was scheduled for a revocation. So I did advise my client that the basis of his violation was 1 charge of obedience to the law and all the charges were nollied. We did have contact with his private attorney. It appears based on the fact pattern, when Mr. Brooks went to court, the bond was reduced to $100 just for credit purposes. And also, I believe we received information. There were 5 counts of risk of injury. And I believe the basis of the risk of injury was the allegation of some verbal back and forth between Mr. Brooks and the female victim. There were 5 children apparently in the room. That's the basis. I just want to make sure it's clear for the record. Mr. Brooks was not involved in anything with the children. The children were just in the room. But they did take a look at that. It took a while for them to investigate things, speak to the victim in this matter, and she did provide an affidavit. That affidavit was provided in court also, obviously, and all his charges were nollied. Mr. Brooks, is that a fair recitation of the facts of what happened in your case in court?
Yeah, it just took a while for them to get the video footage. But once that was attained, it was pretty much done.
Okay. And you were out from approximately 11 months out in the community, and but for this issue is why you were remanded, correct?
Yeah, I was home for a week with him in a year exactly, unfortunately.
Okay. And I just want to add one thing onto the record before we go on, but you've been advised, unfortunately, of what happened to your dad this weekend, correct? So I don't want to be the one put on the record.
Yeah, I found out Saturday morning.
Okay, so I just want to put on the record, I did receive a call. I've been in contact with his mother on more than one occasion, but I just got a call this morning at about 8:45. Mr. Brooks, his dad, unfortunately passed away in the early morning hours of this past weekend, Saturday morning. And his mom did tell me that she was able to get a message to Mr. Brooks regarding that situation. So sorry for your loss.
Sorry for your loss also, Mr. Brooks.
Thank you, I appreciate that.
I don't have anything else to add regarding the first part of the hearing.
Okay. Thank you. Stage microphone. All right, so I've separated the charge of obedience to the law, charge number 1, into separate parts. And I'm going to make a partial finding. So I'm making a no finding for the charges against you for the risk of injury, the 5 counts of risk of injury to a child based on this, or because the state has failed to submit sufficient evidence to meet the preponderance standard for those charges. I am going to make a finding that you violated the charge, or for the charge of disorderly conduct, because although it was not laid in court, it doesn't negate that the conduct occurred. So with that, the evidence in support of that charge is states exhibits A, D, E, and F. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I'll recommend. So counsel?
Yes, on behalf of Mr. Brooks, I am going to respectfully request he be reinstated as soon as possible for a couple of reasons. One reason here, he made no finding on the risk of injury, and he made a finding on disorderly conduct, although the charges were not laid to court. A disorderly conduct is a C misdemeanor, which carries a 90-day penalty under Connecticut general statutes. And my client's been going on 6 months on June 25th for a C misdemeanor, which was not laid in court. I understand, and I'm sure it's going to be brought up. He's been here before. We're not disputing that, but there was police contact. But we also need to look at the disposition of what happened in court here and your partial finding. My client is 35 years old. He does have 7 children. One of his daughters was just born on March 2nd of 2026. Upon his previous release, he did successfully complete the Renaissance Halfway House program in Waterbury. And then it looks like in February of 2025 to December of 2025, he was sponsored by his brother, Mr. Gibson. He's also previously sponsored by his mother. As far as his employment history, he's always worked while he's out in the community. He had a full-time job at Home Goods Distribution in Bloomfield for a few months. Then he was a full-time detailer at Avis Car Rental in New Britain, and also full-time C-shift lead at Home Goods in Bloomfield. He's been employed at Home Goods for approximately 4 years and working 16-hour shifts. He was out for 6 months. Fortunately, Mr. Brooks was involved, and he was a victim of a shooting, so he has some physical issues. He did participate in a intake evaluation while at Renaissance at the Wellmore Behavioral Health in Waterbury. He did go. He was not clinically recommended for treatment. He did participate in the Explore Domestic program. Did indicate to us he completed 21 out of the 26 sessions at the time of remand. He did establish his medical care at Hartford Hospital because of the shooting. And because of the shooting, he did lose one of his kidneys, and he does suffer some medical issues to this day because of that. He was on a minimum contact during his contact. He did list his sister to be his sponsor, Ms. Smith. I provided you with her address and a phone number. He does want to enroll in tractor trailer school to obtain a CDA license, and he indicated to us he is able to return back to his full-time job at the Avis Car Rental in New Britain. And obviously he's eager to reunite with his daughter, who was just born in March. Shalik, anything I left out about your background or what you want to do when you get out? If you want, anything you want to add, you feel I left out, now's your opportunity to add.
I'm pretty much, everything you're saying is accurate. The only thing that probably changed was over the weekend when I found out about my dad. Like, we have, I don't know if you guys are familiar, we have tablets now. So I woke up to about 10 messages from loved ones. And it's just tough. Like, that's pretty much all I have to add. Everything else is accurate about my job. My mom was in contact with them. They said they sent you, I believe, a letter. My kids, I'm very active in their lives on a regular day, every day, for going to school, the doctor's appointments, and, just this was a misunderstanding. I honestly don't want to sound cliche, but I feel like I did everything I'm supposed to do as a parolee and not being combative, not being physical, not here now in front of you guys. So that's pretty much it.
Thank you, Mr. Brooks. Just take a moment and I'm going to announce my recommendations. So I have listened to the testimony today. I've reviewed all the evidence submitted. As the council mentioned, this isn't your first violation, which is what is concerning. This is actually your fourth violation from what I have. But there was a partial finding found today. With that, Mr. Brooks, I'm going to recommend your parole be revoked and that you serve and you were out in the community. It's that I have for about a year, like you stated too, which is a decent amount of time working too. And I appreciate that part of it. So I'm going to recommend your parole be revoked and that you serve an approximate 6-month period of confinement as a sanction. That's with the re-parole date of June 25th, 2026. I'm going to recommend the following conditions: no alcoholic beverage consumption, behavioral management program for domestic violence, no contact with the co-defendant William Cole and Jonathan Moret, no contact with your victim GC, DH, and HW, a general no contact with DB without parole officer's permission, no operation of a motor vehicle without your parole officer's permission. And I am going to note that you have your sister as a sponsor, but I'm going to do halfway house placement because I'm recommending your re-parole the same date as the board review date. I don't think Parole and Community Services will have enough time to do their necessary background check into your sponsor. I don't know, it'll be up to them, but just in case, that way you have somewhere to go if the board accepts the recommendation, okay? So what happens next, Mr. Brooks, is that my recommendation is going to go to the board on that date, June 25th. The board can do only 2 things. They can adopt it and you'll be released that day. And then if for any reason they would want to see a period of confinement longer than the 6 months, they'll ask you to come back for a 3rd hearing to address their questions and concerns before anything longer is imposed, okay?
Okay.
So, Shalik, the way this, she just explained it to you, the way you'll know if they adopted the recommendations, because it's the same day as board review, if you get released that afternoon next week from Thursday the 25th, that means they adopted it. If you don't get released, that means they rejected it. There's another hearing. I'll have to set up a call with you, go over the next step. But because it's on the same day, I can't get to you in between. So you'll know that day if you're out or not.
Okay, thank you,
All right,
guys.
all right, good luck to you. Sorry about your dad.
Yeah.
I appreciate you guys. Have a great day.
Take care.
This concludes the revocation hearing for Shalik Brooks, inmate number 341751. Good luck to you, Mr. Brooks.
All right, thank you. Have a great day.
Thank you.
Hi,
Good morning.
morning,
How do you
morning.
say your last name?
Sorry.
Kassar. All right, Mr. Kassar, I'm
Yes.
just gonna, your attorney should be coming in and we have Officer Katie here, so we'll get
Okay,
started in a moment, okay?
Okay, thank you.
Great. Good morning, Officer Haight.
Morning.
Morning.
We're gonna get started. So good morning, I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Aidis Kassar, inmate number 401932. Today is Monday, June 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Me, Aidis Kassar, 401932.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office and Mr. Kassar.
Thank you. And also present is your charging officer. Can you please identify yourself for the record?
Parole Officer Haight from the Bridgeport District Office.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note that you have been referred to the Department of Corrections for diversion for substance abuse programming and treatment. If by the end of this hearing, I determine that you should be held in prison pending further proceedings, I'll provide additional information about the diversion process. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Kassar and Officer Haight, can you both please raise your right hands? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for today. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
Not at the moment.
Okay, so we're going to go over your rights then for today's hearing, because you do have important rights. The first is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Thank you. So we're now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So Officer Hay, can you please review the charges for us, starting with number 1?
Charge 1, program participation. On 5/20/26, you became verbally aggressive with the prescriber at Liberation House for refusing to prescribe you Wellbutrin. As a result, the prescriber refused to continue to meet with you to manage your medications. On 5/27/26, you were unsuccessfully discharged from the Liberation House inpatient substance abuse program for being observed sniffing your medications, possessing an unauthorized pet bird, and destruction of program property. Charge number 2, drugs. On or about 5/27/26, you improperly ingested Seroquel intranasally in a manner inconsistent with the proper administration of this prescription. Charge number 3, mental health evaluation and treatment deemed necessary. On 5/20/26, you became verbally aggressive with the prescriber at Liberation House for refusing to prescribe you Wellbutrin. As a result, the prescriber refused to continue to meet with you to manage your mental health medications. On 5/27/26, you admitted to improperly using Seroquel, a psychotropic medication, in a manner not directed by the prescriber. As a result, you were unsuccessfully discharged from the Liberation House inpatient program.
Thank you. You've also submitted evidence in support of the case. Can you please identify the evidence for us?
Exhibit A, remand to actual custody order. Exhibit B, conditions of parole. Exhibit C, notice of parole violation. Exhibit D, notice of parolee rights. Exhibit E, parole violation report. Exhibit F, offender misconduct. Exhibit G, voluntary drug admission. Exhibit H, liberation programs discharge summary. Exhibit I, drugs.com/Seroquel. Exhibit J, FDA approved medication guide for Seroquel. And Exhibit K, revocation hearing summary.
Thank you. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, I did.
I have not received anything from the defense at this time. Do you need time to submit any documents?
I do not know.
We don't have any witnesses. So at this time, it is the state's opportunity to make a short statement and testify with respect to probable cause and the severity of the allegation. So Officer Kate?
This is his second time he had issues at an inpatient program. He was discharged for similar behavior, basically the same behavior from App Foundation on his last parole violation. Also, the behaviors prevent the, that he provided the psychiatrist at Liberation, basically demanding a certain prescription from her, or essential to the issues Mr. Kassar is having. He's on supervision, which is all centered around prescription medications. We're definitely seeing a pattern here. For charge 2 drugs, again, this is the second time he's done the exact same thing, crushed up his medication and snorted it in his room at an inpatient program and got discharged as a result. Now the program, they also had me meet with him a week before he was discharged because he was demanding Wellbutrin from the psychiatrist there. And then the reports that I received was that he had obtained it from outside sources or other residents in the program. And that's the drug he was snorting in his room. However, when I met with him, he told me it was his prescribed Seroquel that he was snorting. Charge 3, mental health evaluation treatment deemed necessary. Kassar has a mental health STIP, which requires him to receive and participate in mental health treatment. However, he keeps trying to manage his own medications by crushing and improperly using his own meds or demanding medications that he's not being prescribed by certain prescribers. So he's not been compliant with mental health treatment either. Nothing else adds to the charges.
Thank you. And counsel?
Thank you. Mr. Kassar, with regard to the TOP program, have you started the program since you've been remanded?
Yes, it's been, ever since I came here to Carl Robinson, I've been doing it, yes, successfully so far.
And you're willing to engage in that program? You understand what it entails?
Yeah, of course, of course.
All right. And can you just briefly explain what happened with the bird while you were in the Liberation program?
Well, I mean, we were outside in the backyard and we were smoking. It was raining, and I saw a bunch of bones and feathers and stuff. And I know we have a raccoon in that backyard, so I'm assuming the raccoon got into the nest. And I looked a little better in the corner. There was a little tiny fledgling. So it was like. I just took it, I put it in a shoebox up in my room. I just wanted to keep it until the next day when it got sunny so I can release it. The window screen in the room, it was ripped off. Somebody ripped it off and folded it and tucked it in between the two windows. So I just took a piece of that and I put it on top of the box, just so the thing doesn't come out, just doesn't jump out. And I fed it with some bread, and the next day, literally, I was going to release it around lunchtime when we go after lunch when we go out, but they were searching the rooms for food, and that's where they found it. I didn't realize it was going to be that big of a problem because 3 staff members, we always have staff members outside with us smoking, they saw me take it, but they were like support staff. They weren't no directors or assistants or anything like that. So it was just my...
All right, thank you. I think that does provide a little more explanation. Thank you. So I think it's pretty clear he has been battling with substance abuse issues for some time. Parole did attempt to give him some treatment while he's been on parole. And then he did provide a little more explanation with regard to that one incident involving the dog with the bird. He is willing to engage in the TOP program. And I have nothing else to add at this time.
Thank you. Officer, anything additional at this time?
No, nothing else.
Okay. All right, Mr. Kassar, so I am going to announce my findings. So on charge number 1, I've identified it as 2 separate parts, each part identified with a date as charged, and I'm making a partial finding. So I'm going to make a no finding for the part dated 5/20/2026 as the evidence provided does not support the elements for the charge of program participation. I am making a finding for the part dated 5/27/26 based on the evidence in states exhibits B, E, and H. Charge number 2, the condition of drugs. I'm making a finding of probable cause based on the evidence presented in state's exhibits B, E, G, and H. And I've also identified charge number 3, mental health evaluation treatment, as 2 separate parts, each part identified as a date as charged, and I'm also going to make a partial finding. Again, a no finding for the part dated 5/2026, as the evidence provided does not meet the charge of mental health evaluation and treatment as deemed necessary. And I am making a finding of probable cause for the part dated 5/27/26, based on the evidence presented in state's exhibits B, E, and H. I'm also finding that the acts are serious enough to warrant revocation and that you should be detained while you await that revocation hearing. However, Mr. Casardo, you have been referred for the diversion program by Parole and Community Services. And what that means is if you wish to participate and apply, and I find that you meet the eligibility criteria, I can continue your case while you are provided the opportunity to participate in that substance abuse programming and treatment while at the correctional facility. What happens is if you successfully complete the program and treatment provided, I will dismiss your case and your parole will be reinstated. If you do not complete the program and treatment provided, the board will then schedule and convene a revocation hearing to determine if you have violated the conditions of your parole. If so, at that hearing, a hearing examiner will make a recommendation as to whether your parole should be revoked and what, if any, sanctions should be imposed. So, Mr. Casar, the decision to participate in the diversion program is completely voluntary. So do you understand the diversion process and do you wish to apply for it?
Are you talking about TOP program?
Yes.
Sorry, I'm not,
Yep.
continue it?
Yes.
Oh, of course, that's what I've been doing, yeah.
Okay, all right, so then I'm gonna announce my findings with respect to your eligibility for it. I do find that you have no pending misdemeanor or felony charges. I'm also finding that your discharge date is more than 60 business days from the date of your remand to custody. I also find that there's evidence that you've identified substance abuse treatment needs. I'm also finding that the substance abuse is reasonably considered to be a motivating factor of your alleged failure to comply with the terms of your conditions of parole. And I'm also finding there is some evidence that you were provided with opportunities to receive the substance abuse programming during, in the community. So I am finding that you are eligible, Ms. Casar. So what I need you to do before I accept your application is to indicate whether or not you understand the following statements by saying yes or no. So the first statement is, I understand that I will remain incarcerated while I receive programming and treatment and that parole revocation proceedings may be delayed as a result.
So that means that I'm going to the program, I understand that I'm in the program, and if everything goes success, okay, yes.
Yep, perfect. I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Okay, yes, I understand that.
Okay. I understand that ultimately the Department of Corrections will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yeah, okay.
Okay, and I understand that my participation in this process is completely voluntary.
Yes, I understand that.
Perfect. So we are going to accept your application. It is granted. So what happens now, Mr. Casar, is you continue that program and we'll be notified when you complete it to reinstate your parole. The longest it'll be is no more than 60 business days. Okay.
Okay.
Any questions?
Not at the moment,
All right, thank you.
Said this includes the preliminary hearing.
That's it, you're all done. You said complete the program, okay?
Okay, of course.
Exactly.
I've been
All
doing
right.
it. All right, thank you, officer. Thank you, sir and ma'am. Thank you very much.
Right. This concludes a preliminary hearing for Nick Casar, inmate number 401932. Good luck to you, okay? Thank you, Officer Kate.
Thank you. Bye. Thank you. Bye.
Bye. Good morning.
Morning. All right, come on down. It looks like everything looks good.
Good morning.
Good morning.
Good morning, Alex.
Sorry, good morning. It is 10:13 right now. We can't get started until exactly 10:15, so we'll get started in 2 minutes, okay?
Okay.
Good morning. I am Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Tyshawn Boykin, inmate number 265207. Today is Monday, June 15, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborne Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Tyson Boykin, 265207.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Attorney Alexander Taubes, juris number 437388.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to the panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. Testimony at today's hearing will be taken under oath. So Mr. Boykin, can you please raise your right hand? You solemnly swear, solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for today. First, I'm going to read you your rights. Then we're going to review the parole violation charge that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So you have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. You understand these rights, and are you ready to go forward?
Yes, ma'am.
We will now review the charge that the state, your parole officer, is bringing against you and the information underlying that charge. So on charge number 1, the condition of obedience to the law, the charging officer reported that on 11/13/2025 during a routine traffic stop, Connecticut State Police report you possessed illegal narcotic cocaine. Due to your action, most notable possession of cocaine, Connecticut State Police placed you under arrest with the following charges: possession with intent of narcotic substances, possession of controlled substance, third sub SBS offense, and failure to wear a safety seatbelt, and illegal operation of a motor vehicle without tint inspection. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the Connecticut Conditions of Parole; Exhibit B, the Connecticut Board of Parole Remand to Custody Order; Exhibit C, the Notice of Parole Violation; Exhibit D, the Parole Violation Report; Exhibit E, the Connecticut State Police Investigation Report number 25004019333; Exhibit F, the Connecticut Judicial Pen and Case Detail; Exhibit G, the Parole Revocation Hearing Summary. I do want to note on the record that I did not receive Exhibit F, the Judicial Pen and Case Detail, so that exhibit is not going to be admitted into evidence for today's hearing. The state did file an addendum to the parole violation report on May 14th, 2026, that states that on May 12th, 2026, the offender was seen in GA 23, and the following case was disposed. It was, what do we have? The offender was pled guilty and found guilty on the possession with intent to sell and dispense narcotics and was sentenced to 1 year jail. The previous charge of possession with intent to sell narcotic substance and possession of controlled substance third were cleared. They have removed in parentheses to make room for the one charge, and there is no disposition to the removed charges. The charge of failure of the illegal operation of a motor vehicle without tint inspection and failure of operation for passenger of a motor vehicle to wear a seatbelt were marked nollie, and there are no pending charges at this time. So counsel, just to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes.
Okay, and I did just receive the exhibits. Attorney Taubes, I have not been able to review them, so I am not going to be able to admit them into today's hearing. Would you like to testify in regards to them, or would you like to continue today's hearing to next week so I have time to review what was submitted?
We can continue it to next week.
You want to continue to next week? Okay.
Yeah, no problem.
All right, so I'm going to continue today's hearing then to next week, Thursday, June 25th. And then that will give me time to review the documents that have been submitted by counsel.
And just one thing, that while you review them, it's kind of sensitive, but I think it's really important. The evaluation where the state recommended treatment for Mr. Boykin, that's Exhibit 3. It talks about the trauma that he experienced as a boy. And we think it's very significant that he did not end up in that trauma by chance. He was a child who the state was responsible for. And he was in the state's care. And we view Mr. Boykin's journey as one where the state can finally be a part of helping him to cope through a better treatment journey forward. And so I just would like you to read those documents with that in mind.
Absolutely. Okay, so my next hearing is next Thursday, the 25th. That's okay?
That's fine.
Perfect. I will send you my preliminary docket. It's going to come out this Thursday. I'll send you a copy of that so you know the time slot, and then final docket will come out 2 days before to let you know for sure. And we'll send you a new invite, okay?
Always very thorough, officer.
Always try to be, okay? All right, Mr. Boykin, we'll see you next week, okay?
All right.
All right, so
Give me a call, Ty.
Okay.
all right. Thank you both. I'll see you then. Have a great day.
You too.
Bye.
And I'm going on the record that the case for Darius Moody, inmate number 370226, was waived by his attorney, so that will not be going forward today. Thank you.
Thank you.
The screen. Hello.
Hi.
Hi, how are you? I'm sorry. I'm just having a little bit. Who are you here for?
Montanez and Mathis.
Oh, they're both together in the same, or are you
One
doing it
after-
separate?
Yeah, separate, please. So Montanez first.
Okay, so they're on their way down now. So just give me like 2 more minutes. Hopefully it'll be
Perfect. All right,
All right.
sounds good. Thank you.
I'm trying to see why I cannot see the screen.
Yeah.
Good morning,
Hello?
Mr. Montanez. How are you? Hi, thank you. Mr. Montanez, it is 11:26. We cannot get started till exactly 11:30, so we'll get going in 4 minutes, okay?
All right, so that's when the video gonna come on?
The video is on.
I
Yep.
can't see you. I can't see her.
Yeah, she'll come on when she's ready.
Oh, when you're ready, you'll come on?
Can you ask the CO to come back in the room a moment?
Once you come back in.
Yes.
Officer, I know you were having trouble with the screen before, and I can try to help you walk through it. Can you just tell me what it looks like at the moment?
No, so like, you know how we have like a TV and then like a little monitor to control the TV?
Yes.
It's the little monitor, like it's just completely dark. But usually, like the person on, like you would turn the cameras on, because our cameras, you can't see us?
No, we see you. The camera is already on.
Okay, yeah, so he can't see you is what he's saying, but you guys usually turn your camera on when you're ready, right?
No, so everyone's camera is already on. So on the television, do you see yourself?
No.
So you don't see anything on the TV?
Yeah, we just see like the DOC, it says PO Trucello revocation hearing, room 1.
Okay, so what I'm gonna have you do is, do you have the power strip there where you can just turn all the equipment off?
I have like the extension cord here, like that's plugged into the wall.
Yeah, because on the little screen, the tablet itself, you don't have any buttons that you can press,
Yeah,
right?
there's like
It's
a
all
little
black.
control. Yeah.
Okay, so what I'm gonna have you do is we're gonna hang up the call, and then I'll just have you turn the power strip off. Wait
Okay.
10 seconds, and then turn the power strip back on.
Perfect. We'll do that.
And then as soon as I see you come back on, I'll send you this call again.
All right. Sounds good.
Thank you.
Hello?
Storm 2, can you send out 70 bunk?
Can you hear us?
We can hear you, but we're still having the same issue with the little monitor. It's still black. Are you guys able to call into one of the other TV rooms?
Officer Trucello, if she says that room 2 is available, we could do that.
That's fine. I mean, we can see everything. It's just you guys over there that can't see us. So, I mean, we can try room 2. That'll work.
Yeah, room 2, I don't have anything till 2 o'clock in that other room. So if you guys want to call in there, everything's working.
Okay.
Yeah, we'll call over now. Thank you.
All right. You're welcome. There we go. Excellent.
Hello?
You can see us?
Yes.
Awesome. All right, we're gonna get started, okay?
Okay.
All right, so good morning. I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Joshua Montanez, inmate number 329535. Today is Monday, June 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Hartford Correctional Center. Can you please state your full name and DOC inmate number for the record?
Joshua Montanez, 329535.
Thank you. So this is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. Montanez.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Montanez, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for today. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
All right, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. You understand these rights, now you're ready to go forward.
Yes.
We'll now review the charge that the state, your parole officer, is bringing against you and the information underlying that charge. So in charge number one, the condition of absconder, the charging officer reported that on 4/7/2026, you were re-released to special parole and placed in your only approved residence at 24 Central Ave, Waterbury, Connecticut. At this time, you were instructed on and agreed to all conditions of your special parole, as well as rules to the residents at the halfway house. Those conditions include that you will live in your residence approved by your parole officer. 24 Central Ave, Waterbury was your only approved residence. On 4/12/26, you left the residence and failed to return. You failed to contact your parole officer, and your whereabouts in the community remain unknown until your parole officer and parole and community service, unknown to your parole officer and parole and community services until you were located by East Hartford Police on 4/28/26. Your whereabouts were unknown for 17 days. The states did submit evidence that was already identified at the preliminary hearing. That all does remain the same. So counsel, just to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents for today's hearing?
Yes, I did.
Great. I did receive one exhibit from the defense. I have exhibit one, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
I do not know.
Don't have any witnesses. So at this time, it is the defense's opportunity to present evidence and speak to any of the evidence submitted. So counsel?
With regard to the single charge, I'm just going to briefly reiterate from the record of the preliminary hearing. Mr. Montanez, who was only unaccounted for about 2.5 weeks at the time he was remanded. No absconder warrant had been issued at the time. He does acknowledge that substance abuse and mental health issues overwhelmed him very early in his supervision here, and he is apologetic for his actions and what happened here. I would argue that given the brief time frame he was unaccounted for, there's insufficient evidence to establish that he intended to permanently abscond from supervision. If there is a finding, I would like to hear further with regard to the sanction. Thank you.
Thank you. Just take a moment and then I'll announce my findings. On charge number one, Mr. Montanez, I am making a finding that you violated the condition of absconder based on the evidence presented in States Exhibits A, D, and I. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, I'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what I'll recommend. So counsel?
Mr. Montanez, he's 38 years old. He was born and raised in Connecticut with his family. His parents, they still reside in Connecticut in East Windsor, and he has a good relationship with them. They are a source of support for Mr. Montanez. He has additional family throughout the state, including 2 siblings as well as extended family. When he is released, he is hoping to be sponsored by his parents in East Windsor. I know he hasn't really done well in the halfway house in the past. He does feel like, given some of his mental health struggles, he may do better in a more comfortable and supportive environment that his family can provide for him. And he is hoping that this request would be approved. If it's not possible to be sponsored by his parents, then Mr. Montanez would be seeking placement in a halfway house in the Hartford area. In the past, Mr. Montanez, he has worked as a barber. He is looking to continue that when he's released. He has been in contact with a previous employer who owns a barber shop in Hartford, and he has been informed that they will be able to hire him when he's released from incarceration. So in addition to working as a barber, Mr. Montanez is looking into obtaining his GED as well as completing cosmetology school. He had started that in the past. He did have some difficulties in school when he was younger, but however, he's always had a goal of getting his GED, and this is something he's going to continue working on. In the transition from incarceration, I think getting immediately involved in treatment is going to be essential for Mr. Montanez. He has struggled in the past in the halfway house. It has been difficult for him to maintain sobriety. He does really want to get placed into a long-term inpatient dual diagnosis treatment program, and he's hoping Parole can help him in getting that set up for him. I think the outpatient and the IOP programs he has been involved in the past, they just haven't been sufficient to address his issues, both his substance abuse and his mental health issues that he's been struggling with for his entire life. He thinks he hasn't been in a long-term program before, and he thinks it's going to benefit him and help him working with Parole and getting set up on the right path so that he can do better the next time he is released. Also, he's on methadone now. He's hoping to continue that when he's released. But rather than just a program that strictly addresses substance abuse, I do think that a dual diagnosis program would be beneficial for Mr. Montanez, as there are a lot of fairly significant mental health issues that also have contributed to some of the struggles he's had in the past with Parole. He is currently on medication. He does feel the treatment he's receiving in jail is very helpful. He wants to make sure the medication is continued when he's released. And again, that he gets into mental health counseling right away. In the past, he told me that he felt he was self-treating some of his mental health disorders with street drugs. So he's hopeful that if he gets on, if he continues with his medication, if he stays on the methadone as well, that would be able to help him transition and perform better when he is released onto parole. So he was only out a few days. He couldn't really stay clean, and he's very apologetic, and he's sorry that he wasn't successful with his supervision here. Parole is recommending at least a 1-year sanction. I would ask you to consider a lesser sanction. I'd ask you to consider 4 months. He has a lot of deep-seated and significant challenges here that did get the better of him. I agree that just releasing him and trying the same thing again may not be the best strategy to address all his problems. I do think getting him into a dual diagnosis program, getting him on his mental health meds and methadone, and I'm also hopeful his parents can be approved as a sponsor. I think that additional assistance would help him try to do better and address some of his issues. My understanding is his mother is the one who actually contacted the police and turned him in here. So I don't think this is a situation where they're enabling him. I think they really want him to do well and get help and succeed. He did abscond quickly here, but he was also apprehended quickly. So it's not as though his whereabouts were unknown for an extended period of time here. There's no allegations he engaged in any additional criminal conduct during those 2.5 weeks. He has a lot of challenges, but he does want to take the steps needed to improve his life and overcome these challenges, these substance abuse issues that he's been dealing with. As I indicated, he's really sorry about what happened. I know it doesn't look good on paper here, but he does want the board to know that he wants to do well. He wants to address these issues going forward. Mr. Montanez, is there anything you'd like to add at this time?
No, sir.
Thank you, counsel. All right, so I have listened to the testimony today. I've reviewed all the documents submitted. I just want to note on the record, Mr. Montanez, this is your second violation on special parole. You were only out on supervision for about 5 weeks before you absconded. Was it 5 weeks?
No, it's
5 days. Yeah, 5 days before you absconded. And you were, as counsel noted, unaccountable for like a week and a half, 17 days. Parole and counsel noted Parole and Community Services has requested a year. With that, Mr. Montanez, I'm going to recommend that your parole be revoked and that you serve an approximate 6-month period of confinement as a sanction. That's with the re-parole date of October 28th, 2026. I'm going to recommend the following conditions. Behavioral management program for domestic violence, no contact with co-defendants Luis Hernandez, Joseph Berry, and Yvette Torres Rivera. No contact with victim MJM or CLH. A general no contact with KA. Mental health treatment. I will do a halfway house just in case, but I'm going to note your mom and dad as your sponsor. So what happens next, Mr. Montanez, is that my recommendation is going to go to the board on June 25th. On that date, the board can do 3 things. They can lessen that recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back for a 3rd hearing to address their questions and concerns before anything longer is imposed. So that does conclude today's hearing. But Mr. Montanez, I just want to make it clear too, this is going to be a long period of supervision. If you just go out and take off, it's going to just prolong it. We add the time to it. It's just, I mean, try to reach out for services rather than taking off if you can. You got to advocate for yourself first.
Yes.
Definitely. Otherwise, I mean, this is just, like I said, going to be a long period of supervision. Okay.
Okay.
All right. Any questions, Mr. Montanez?
No, ma'am.
All right. So then that does conclude today's hearing. The revocation hearing for Joshua Montanez, inmate number 329-535. All right, good luck to you, Mr. Montanez. You'll get notice in the mail about a week or so after June 25th of what the board decided, okay?
All right, thank you.
All right, good luck to you. Thank you, counsel.
Thank you, Matthew.
Thank you.
Yep.
So we don't get three all the like super brand new stuff.
Great. Good morning, Mr. Mathis. How are you?
Good morning, I'm fine, and yourself?
Good. So I just want to know on the record that this hearing was scheduled to start at 11:30. Parole Community Services charging officer is not present for, has not been here within the 5-minute time frame for procedures. We are going to start this hearing now. So good morning, I'm Parole Officer Trisell, and I'm hearing examiner for the Board of Pardons and Paroles. This is the preliminary hearing concerning Brian Mathis, inmate number 372016. Today is Monday, June 15th, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Hartford Correctional Center. Can you please state your full name and DOC inmate number for the record?
Brian Mathis, 372016.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Sure. Attorney Alfonso Sirico with the Parole Revocation Unit on behalf of Mr. Mathis.
Thank you. So this is a preliminary hearing which has 3 purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause being determined that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Mathis, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. You will then have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am. Is my pro officer, like, is he in on this?
He is not here. He did not, he was asking to be present, but he's not present today. Would you want to,
That's up to Mr.
do you want to continue this for him to be present?
No, it's not. No, it's not that. Just he still. I've been trying. He still has some of my belongings. Like he has my cell phone, and I've been trying to figure out, like, am I ever going to get my phone back, or
Yeah,
what's going
Mr.
on?
Brian, I'll put that on the record, as I told you I would. I was gonna ask him about your phone, but he's not coming, so I will put something on the record at the appropriate time about your phone, okay?
All right.
So we're going to go over your rights for today. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. If you understand these rights, now you're ready to go forward.
Yes.
So we're going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. So on charge number 1, the condition of GPS, the charging officer reported that on 5/19/26, you're placed on GPS monitoring. You were in violation of your GPS shutting down on 5/19/26 from 4:56 p.m. until 5 p.m., 5/22/26 at 9:30 a.m. to 11:40 a.m., and 10:28 p.m. to 10:34 p.m. On 5/23/26 from 7:59 p.m. to 8:04 p.m. On 5/24/26 at 11:10 a.m. to 1:32 p.m. and 5/25/26 at 1:30 a.m. to 1:33 p.m. You were in violation of GPS agreement. On charge number 2, the conditional behavioral management program, the charging officer reported that on 4/21/26, you failed to attend your first session of your special parole stipulated domestic violence group at Wheeler Clinic. You informed this PO that you began employment and went to work. On 4/28/26, you failed to attend your second group session for your special parole stipulated domestic violence group at the Wheeler Clinic. You informed this PO that you began employment and went to work. On charge number 3, the condition of general no contact, the charging officer reported that upon reviewing your cell phone on 5/4/26 and 5/26/26, you had contact via cell phone on 4/24/26, on or about 4/27/26, 4/28/26, 4/29/26, 4/30/26, 5/16/26, 5/18/26, 5/19/26, and 5/20/26 with your general no contact TG. It should be known that after PO originally confiscated offender's phone on 5/1/26 and gave it back on 5/15/26, he changed Miss G's name to Do Not Answer. And on 5/18/26, you left TG's home at 5:29 a.m. and was transported by Lyft to your employer in Manchester. You originally signed out of the halfway house at 4:23 a.m. to go to work in Manchester. There was a photo evidence in your phone from your Lyft ride. On 5/20/26, TG sent you $20 through Apple Pay. You were in violation of your conditions to have no contact with her. On 5/26/26, you informed parole officer Miller, Stickles, and Miss PO that you were at Miss G's residence about a week ago having intimacy. This would tie your Lyft visit on 5/28/26. Charge number 4, the condition of halfway house placement. The charging officer reported that on 4/8/26, you were given a pass from the halfway house to go to the library from 3:40 p.m. to 6 p.m. You failed to return to the facility at the designated time. Staff attempted to contact you, however, no phone number was available in the system. At approximately 6:44 p.m., you contacted the halfway house and reported that he had missed the bus and was on his way back to the halfway house. You returned at 6:52 p.m. carrying KFC. You were unaccountable in the community for 52 minutes and deviated from your approved task. On 4/18/26, halfway house staff conducted their house count at 4 p.m. When they opened the door to your room, they observed a THC vape on your bed. You were in violation of the halfway house agreement. On 4/18/26, due to having a vape in your possession, you were placed on smoke break restriction for the rest of the evening, starting at 4 p.m. At 4:15, you failed to comply with your sanction and went outside for a smoke break anyways. You informed staff that they were trying to do you dirty and you didn't care about your restriction. You also continued to attend all smoke breaks up until 10 p.m. On 4/20/26, you were given a pass to attend work at USDA in Manchester, Connecticut. You left the halfway house at 7:25 a.m. and returned at 5:20 p.m. Upon this PO reviewing your text messages on 5/27/26, you were texting Taj on 4/20/26 at 4:02 p.m. to meet you at 180 Hungerford Street in Hartford by the corner store. On 4/21/26, you were given a pass to attend work in Manchester CT. You signed out at 5:10 a.m. and returned at 4:38 p.m. Upon this PO reviewing your text message on 5/27/26, you text your mother, identified as mommy, in your phone to pick you up from work at 2:30 p.m. You were unaccountable in the community for 2 hours and 8 minutes. You did not have permission to visit with your mother, nor to be transported in the car by your mother. On 4/22/26, you left work with somebody in your in your phone called sport mode. You informed them to grab you from work at 2:30 p.m. For the halfway house, you returned at 4:13 p.m. You were unaccountable in the community for 1 hour and 43 minutes. This information was found after the PO reviewed your text messages on 5/27/26. Sports mode is not an approved driver and you are not allowed in the car without parole officer's permission. On 4/23/26, you were given a pass to attend work at USDA in Manchester. You left the halfway house at 12:21 p.m. and returned at 6:02 p.m. Upon this PO reviewing your text messages on 5/27/26, use text sports mode at 12:36 p.m. saying, "Was good, gang. You want to grab, I roll up." Sports mode informed you that he was on the way to pick you up. On 5/1/26, you were given a pass to attend work at USDA in Manchester, Connecticut. You left the halfway house at 5:14 a.m. and returned at 5:36 p.m. Upon this PO reviewing your messages on 5/27/26, you text Jackie to meet up with you for her birthday. You informed her get off work at 4 p.m. For your text message, you clocked out at 4:43 p.m. for her to smoke with you, as you could be out until 6:30 p.m. She informed you that she couldn't meet with you again. You did not head directly back to the halfway house upon leaving work. You are in violation of the halfway house agreement. On 5/12/26, you were given a pass from the halfway house at 9:55 a.m. to attend your domestic violence group at Wheeler Clinic, located in Hartford per your special parole conditions. Treatment started at 11 a.m. until 12:30 p.m. Your scheduled return time was 1 p.m. You walked to the program from the halfway house. Your trip would be 26 minutes. You reported that you took the bus, which would drop you near the halfway house at 12:57 p.m. On said date, this PO Miller, and PS Blue said, "We're in the halfway house addressing another matter. When we were informed you called at 12 p.m. to report domestic violence group was running late and you could not, you would need your time extended. Halfway house staff contacted DV group and they confirmed group ran on time and was released on time. You arrived back at the halfway house at 1:47. PS Blue addressed you regarding your tardiness. You reported group ran late. You were informed that was not true. You continued to report group was let out late until we informed you that we contacted DV group and were informed you were released on time. You then reported stopping downtown Hartford to smoke marijuana. You were unaccountable in the community for 47 minutes. On 5/16/26, you were given a pass from the halfway house at 5:10 a.m. to attend work at USDA in Manchester. You returned to the halfway house at 6:54 p.m. Upon reviewing your text messages, you asked Sportsman to pick you up from Colt Park, aka Bum Park. Said message initiated at 1:05 p.m. on 5/16/26. You do not have permission to be in Sportsman's vehicle and you do not have permission to be at Colt Park /Bum Park. You are in violation of your halfway house agreement. On 5/16/26, you were given a pass from the halfway house at 5:10 a.m. to attend work at USDA in Manchester, Connecticut. You returned to the halfway house at 6:54 p.m. Upon reviewing your text messages, you met with an unknown person to supply him with bud/marijuana. You agreed to meet at 35 West Service Road in Hartford. You were in violation of your halfway house agreement. On 5/19/26, you were given a pass from the halfway house at 10 a.m. to attend your domestic violence group per your special parole conditions. Treatment started at 11 a.m. to 12:30 p.m. Your scheduled return time was 1 p.m. You arrived back at the halfway house at 1:35 p.m. You were unaccountable in the community for 35 minutes. You reported having issues with the bus. You were in violation of your halfway house agreement. On 5/22/6, the halfway house held a mandatory house meeting. You were observed being verbally aggressive with staff and peers, exhibiting frustration with having to attend the house meeting. You continued to walk out of the meeting as you mumbled profanity. Halfway house was unable to redirect you, and you were in a violation of your halfway house agreement. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the remand to actual custody, Exhibit B, the parole conditions, Exhibit C, the halfway house agreement, Exhibit D, the notice of parole violation, Exhibit E, the notice of parolee rights, Exhibit F, the parole violation report, Exhibit G, the incident reports dated 4/8/26, 4/18/26 times 2, 5/12/26, 5/19/26 times 2, 5/22/26, 5/26/26. Exhibit H, the Hartford Police Incident Report dated 4/30/26. Exhibit I, the email from DV Explorer Program dated 4/24/26 and 5/12/26. Exhibit J, the GPS agreement. Exhibit K, the screenshots of offenders' text messages. Exhibit L, the Allied Universal GPS. Exhibit M, the House Smoke Policy. And Exhibit N, the Offender Misconduct Report dated 4/18/26 times 2, 4/30/26, 5/6/26, 5/12/26, and 5/19/26. I want to note that there was a times 2 for that 5/19/26, but I only received one, so only one is going to be admitted into evidence for today. Same thing?
Yeah.
Counsel, just to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified?
I did.
And I have not received anything from the defense at this time. Do you need time to submit any documents?
No.
All right. We don't have any witnesses, so it is now the defense's opportunity to respond and make a short statement with respect to probable cause and severity of the allegations.
Sure. All right. On charge number 1, Brian, the GPS shutdowns, it looks like it's from May 19th, May 22nd, May 23rd, 24th, and May 25th. I believe the May 25th one is about a 3-minute shutdown. Did you ever speak to anyone at the halfway house regarding your issues with your unit?
Yes, sir. So initially upon when I received the GPS monitoring, so that day initially I charged it for 2 hours. Like what I was told to do, and then after I unplugged the charger, and like maybe within like 45 minutes to an hour, the GPS was like, it was vibrating, and like it was showing me that I was like dying. So I reported to the halfway house because my PO, I never had his number. He never gave me a contact information for him. Like when I asked him, can I have his number so I could contact him for any like issues, he told me to just talk to the halfway house or call the parole main office and leave a message. So I relayed the information to the staff at the halfway house and let them know that I was having trouble with my unit, and they said they would let Pearson know what's going on. You know, I go to work every day, so I'm just trying to charge the unit for 2 hours, and it kept giving me problems. And I told them I think I need a new GPS monitoring bracelet. And they said they're going to let Pearson know, and I never heard anything else about it.
All right, so you were charging the unit for 2 hours a day as instructed.
Yes.
You were clearly having issues with it, and you brought your issues to the attention of the halfway house.
I told the higher ups at the halfway house. I let the director know. I let some of the staff know, and they said they will let Pearson know, my PO know what was going on.
Okay. All right, under charge number 2 on the behavioral management program, Brian, 4/21/26, it says you failed to attend your first session in domestic violence group at Willard Clinic. You informed your PO you began employment and went to work. Then it says 4/28/26, failed to attend your second session domestic violence group at Willard Clinic. You informed your PO that you began employment and went to work. It's good, you had a job, correct?
Yeah, so with that issue, so I knew, so initially when I had the interview with Willa Clinic, they told me the dates, like the days, and I relayed to them that I just got employed with my job and that I have orientation coming up, and I relayed to them, is there any way where I could get another day due to the fact that I just started my job, and they told me, they relayed to me that they would let the lady that gave me the interview, I forgot what the lady name was, but she told me that she would relay to somebody, and it shouldn't be an issue with me being able to get my time and day moved until, because I said I don't know exactly what day is on my schedule for my job, but I told her like I could like once I find out, I could let them know. And in the meantime, for that, I know that Tuesday I was going to come, and she said that she'll talk to her supervisor or something, and they like work with me. So I told that to the halfway house as well, and I left voicemails with Willa Clinic and things like that. And so that day when I started work, I thought that maybe they was gonna work with me and give me another day. I never intended to miss my group because I know that's important, but I missed them 2 days. And after those 2 sessions, I went to every other sessions. I never was discharged unsuccessfully from the program. I take full accountability, for missing those 2 sessions. I thought I was going, like I said, I was going to be able to get different days to make up for it, and it didn't work out that way, unfortunately. But I take full accountability, but it wasn't in my plan to miss those days because I know my treatment is number one, like at the top of the list.
Sorry, let's cut you up. I want to get it. You just finished the course at some point, though.
Say that again, sir?
You did complete the classes at some point.
So no, actually, when they remanded me back to custody, I was still going to all the classes. I think I go every Tuesday. And I was going to every class. I just missed those first 2, and after that, I went to every other class. Never was late. I attended. I participated in the group. I engaged.
Okay. Under number, thank you, Brian. The charge number 3, just one subsection of the contact. The incident on May 20th of 2026. That individual sent you the money through Apple Pay, correct? She sent it to you.
I just so if you look at the text messages, you could see like after when they the first time when they intervened and they took my phone and they seen that the contact and they told me to seize contact, I never texted her or called her, and then one day I just received a random $20 Apple Pay.
Okay. You didn't request, you beat me to
it.
I didn't
request it, none of that.
All right, fair enough. Under charge number 4, Brian, I have this, I don't know how the hearing examiner, I have it broken down into, I believe there's 12 different dates, subsections, whatever you want to call it. So under 4, Brian, all the charges under halfway house placement. And
excuse me. Excuse me.
On 4/18/26, regarding the pass to go to the library from 3:40 to 6 p.m. says you failed to return to the designated facility. At the time, they attempted to contact you. There's no phone number available. At 6:44, you contacted the halfway house and reported that you had missed the bus. Is that?
Yeah, so
hold on. Let me follow up on the question. They indicated you were late, and then you got written up for you came back to the house with food in hand where they thought you stopped to pick up food, correct?
Yes, sir.
Okay, what actually occurred?
So initially what happened, I took the bus to the library downtown. I stayed there. I was on the computer. I was trying to, just fill out some job applications. I DoorDash some kid, they have DoorDash, they have Grubhub. I DoorDash food when I was there because my pass was about 3 hours. So I got food there. Then I called them because, like I said, I missed the bus. I came back a little late. I called the halfway house and I informed them that I was running a little bit late. And they said, okay, it's fine. When are you coming? I said, I'm getting on the bus now. And then when I came back on the bus, which I still have my food in hand, but I haven't eaten it all. So when I went inside the halfway, I guess they didn't even say anything about me having food initially at the halfway. They didn't ask me anything about it or anything like that. I'm just finding out now that they saying I deviate, and now that I'm here at this point.
Okay. For number 2, also under the halfway house placement from 418 it goes to, could you let the hearing examiner know regarding the vape pen? What you wanted her to know?
So yeah, the vape pen, I'm not even going to make an excuse for that. I'm not going to say and make an excuse. The vape pen I take accountability for that. I'm not going to sit here.
All right, and I appreciate you putting that on the record because, things you did wrong, you did take accountability. Is that a fair statement?
I'm not going to, yes, I'm not going to make an excuse. I had a vape pen. I wasn't, trying to disrespect the halfway house. I never brung any marijuana or anything like that. The vape pen, I take accountability for that, man.
Okay. And jumping on to the next same day, 418, regarding, they placed you on a restriction, on the smoke restriction because of the vape pen, correct?
Yes. So once I didn't know I was on a restriction until I actually went outside and I tried to get a cigarette from somebody and they told me that I'm on cigarette restriction. So I just stayed outside. At first I already had the cigarettes. I already took a few, pulls of the cigarette, but I gave it back to the person and I just stayed outside for the fresh air. And I did say, I said, they trying to do me dirty here. I said, it's like they're just trying to find any little thing. I did say that, but I didn't smoke. They said that I could be outside, and after that, I never smoked another cigarette.
All right. So your restriction was, in your mind, was.
They told me I couldn't smoke. They just said I couldn't, and I wasn't aware of that at first. But when she told me that I can't smoke, I didn't. She said I could. They said I could stay out there for fresh air. I just couldn't smoke.
All right. So you knew you did go outside, but then you knew you couldn't smoke.
Yes. After yes, and after that, I didn't smoke anymore. I followed the rules, the restriction.
All right. Let me jump on to the number 4, I guess. On April 20th of 2026, you got a pass to go to work, 7:25 and return at 5:20. And all these text messages that they went through your phone was for May 27th. Regarding the text to Taj at 4:20 at 4:02 p.m. to meet you at 180 Hungerford Street, could you let the hearing examiner know what occurred? And I also want her to know who lives at that address.
I don't want to put that on file.
Okay.
I don't want to put that. But so what happened was I was at work. Taj is my female's cousin. She had some money for me. I have a family member that lives over in that area. And I said, meet me there. But it was just an exchange. They was giving $100 to my family for me for being fresh, coming home so I could get some clothes. I just said, just meet me there because my family member and that person, they don't really get along. So I just made it seem like it was me. But once they got there and my family member got there, they just got the money exchange. And that was that. It was just $100 for me to go towards me getting a sweatsuit for me coming home. I was at work the whole time.
Okay. Next day, it looks like April 21st of 2026. They were given a pass to work. You signed out at 5:10 a.m. and returned at 4:38. Could you let the hearing examiner know, once again, they reviewed your text messages on May 27th, the text regarding your mother. Could you let her know what occurred that day?
What, the day when I was at work when I asked to get picked up at 2:30?
Correct.
If I could recall correctly, I don't think that I think that my mom came up there, but she came up there to bring me lunch or some food or something, but I never left with her because I was still at work. The assignment didn't end yet.
Jumping the next April 22nd, Brian, the issue with this person in your phone allegedly, in quotes, sports mode, telling you to grab you at 2:30 p.m. and then you returned at 4:13 p.m.
I don't recall. All right, so sport mode, that's somebody that I met through Lyft, Order and Lyft. And when I met him in the Lyft, basically they told me that I could just take down their number, and anytime I needed them to, like I needed a Lyft or anything, I'll just call them directly. So that's really how that came along. But I don't really remember that day. Like it was so I don't remember that day. That actual instance, I really don't remember. Like
No, that's fine. And that's, I want you to put on the record regarding that. All right, I want to jump to May 1st, Brian, where it says given a pass to attend work at 5:14 a.m. and return at 5:36 p.m. Once again, they reviewed the text messages on 5:27 and indicates you texted Jackie for her to meet up with you. Did you go somewhere or did she come to you? Could you let the hearing examiner know what occurred on that day?
Oh yes, so that day, I did meet up with her. So I got out of work, I took the bus downtown, and we were texting, and they met me downtown, and like on my way waiting for the bus to go back, I smoked with them, hung out with them a little bit until my bus came. I seen her briefly, and then I got on the bus and I went back to the halfway house. It's never was an instance where they came and picked me up from work or anything like that. I just on the way, leaving work, going downtown, returning back to the halfway, they met me downtown. I seen them briefly for about 5 or 10 minutes, said happy birthday, and I continued on my way back to the halfway house.
Okay. Jumping May 12th of 2026, and you and I discussed this here because of the math. You were given a pass at 9:55 a.m. to attend domestic violence, which started at 11 a.m. So you were given an hour and 5 minutes to get from point A to point B, correct?
Yes, sir. Yes, sir. So with that, so every time I had to go to my program, so they give me an hour. So the program starts at 11, if I'm not mistaken. So they give me an hour, ma'am, to get there. And then so when I got to the program, I'm in the class, I thought I got out at 12 for some reason, but I didn't know that the class was from 11 to 12:30. So because once it was about 12:05, 12:10, I asked the lady that was running the program, I forgot her name, but I asked her what time did the program get out. She said 12:30. So I know that they only gave me till 1 to get back to the halfway house. So I asked her, I didn't know the halfway house number because I think they had my phone. They took my phone because I don't know if I had my phone. Oh, I think they took my phone. Maybe I was on restriction. I think that's maybe around the time they had my phone. So I asked the lady that was running the program if she could look up the halfway house number, which she did. I called them and I let them know. I never told them that the group is running late. I told them that I get out at 12:30 and that I'm taking the bus on Farmington Avenue because I told them I don't feel comfortable walking, on the north end. I told them I feel more comfortable taking the bus on Farmington Avenue to downtown and then get on the Albany Avenue bus and taking that bus to the street, to the halfway house and just walking straight down the street instead of just walking through the north end where it's a lot of stuff going on and I'm trying to stay out of trouble. I don't want to, it's a lot of stuff going on over there. So I was just trying to call them and let them know that I needed a little bit more time because I didn't want to get written up or be late. And I didn't understand it because they gave me an hour to get there and then only 30 minutes to get back. And then when I'm getting back late, they're writing me up. But at the same token, there's other people that's in the halfway house that go to the same program and they get an hour to get back. So it just, I didn't understand it. I wasn't trying to beat the system or anything. I just wanted an equal opportunity to be able to get back to the halfway house without getting written up.
All right, fair enough. All right, a couple more, Brian. There's a lot of subsections here. The one on May 16th, it indicates you're given a pass from 5:10 a.m. to 10 work. Once again, you got back at 6:54. Once again, they reviewed the text messages on 5:27 regarding the marijuana.
If you go through my phone, if you go through my phone, those were screenshots. If you have my PO is here right now and you had the phone, you would see that I reached out to a friend, a female friend, that I used to hang out with and smoke weed with before I did my time. And I reached out to them because I had a new number, but they still had the same number. So they kind of was like foggy. They wanted me. So I just sent them, like I screenshotted because I still had our old text messages because, you know, iPhone, it saves all your messages. Like from, if they have the same number, all your messages are still in your phone. So I sent them a screenshot from old messages with me talking and just to show her who I was. And I sent a screenshot of the messages. It was never, those weren't text messages. If you go through the phone, you can see that was a screenshot that me took of old messages and I sent to her phone.
Last one, Brian, regarding the meeting that was held. Couple questions I have for you. On May 22nd.
You good?
Yes,
right?
I'm fine. I'm fine.
Okay.
I'm fine. Thank you.
On May 22nd, 2026, do you recall if you worked on that date, the same day as that House meeting?
Oh, okay. So as far as the House meeting that day, I remember. So I did. I worked that morning. Every morning I get up at 4 o'clock.
All right, hold on. Let me just break it down. You recall working that day, correct?
Yes, sir.
What time do you wake up in the morning?
Every morning I wake up around 3:30 to be able to get in the shower, eat my breakfast, and get ready, get prepared.
Okay, and what time typically do you get back to the halfway house? Between like 4 and 6 p.m. roughly?
Between 5:30 to 6:30.
Okay, and if you recall, what time was that mandatory House meeting held that day?
10:30 at night.
Okay, it's your testimony that they called a mandatory House meeting at 10:30 p.m., correct?
I mean, you guys could run back that day and check the cameras. It was 10:30 at night.
Okay. And was it typical to have a meeting that time of night there?
I mean, I never been in a meeting. That was the first House meeting, but I done been in other programs and like halfway houses, and usually House meetings are either run early in the morning or like the afternoon. I never experienced a House meeting at 10:30 at night.
Okay. As a fair statement, you were cranky and tired that day?
That's so because I had just fell asleep. I just got back to the house. I took my shower at 8 and I fell asleep around 9 o'clock. So when they woke me up for the House meeting, I was grumpy. I'll take accountability. I was grumpy. I did mumble a few things, but it's just because I was tired. And then when he tried to kick me out the meeting and say, you know, just leave, I said, I apologize. I explained to him that I just woke up and I told him I'm going to sit in on the meeting and I won't say nothing. I'll listen.
And so, Brian, I did explain to you, you know, what the purpose of the preliminary hearing was to establish probable cause. And if it was serious enough that you need to be held. I know these are technical violations. Along this time frame, you had no police contact. Is that a fair statement? You weren't charged with any obedience to the law charge?
No, sir.
Okay, and you were working during this time frame, correct?
Yes, I attained deployment my 4th day of being freed, you know.
Okay, all right. I don't have anything else to add. I just wanted to give you a little background on, you know, the perspective from Mr. Mathis regarding some of these things. He did take some action regarding the GPS shutdowns. He was, as his testimony was, he discharged it 2 hours a day. 45 minutes in, he was beeping, and he did follow up on that. He admitted the vape pen. There are things he's not trying, as he indicated, I think his language, I'm not trying to skirt the system, but if he was, he wouldn't come in front of you and admit to some of these things. Go ahead, Brian.
Man, like I know I wasn't perfect. I take accountability for them, full accountability for my action. I know some things I did what I shouldn't have did, and some places I was where I shouldn't have been at certain times. And I'm not perfect. You get what I'm saying? I'm human. But one thing I could say is that I did do a lot of positive things. I attained employment. I went to work every day. I paid online. I got my OSHA 10. I got my flagger certification. You know, like I take like I said again, I take full accountability, you know, for my actions. I don't think that these things should hold me in and keep me from working and stuff. I want to be better. I know I need change, and like I think the bracelet was good for me, you know, to keep me accountable for my whereabouts and stuff like that. But like I said, I tried to inform them and let them know about the bracelet, and it's like, there's only so much I can do, man.
Thank you, Mr.
And before you say, I just want to put one more time on the record regarding his telephone, to make sure hopefully that doesn't get destroyed or sent anywhere. And if the PO was here, I would, ask for that on the record. I know. Go ahead.
I would like my grandmother is my emergency contact, Maddie Johnson, because my bank information, all my money from my work is tied into my phone, and I can't get any commissary or anything. I don't know how long I'm going to be in here.
I'm sorry, can you put, if you want, I think you already put it in, what's the person's name you're willing to release it to?
Mattie.
Mattie, and what's the last name?
Johnson, Johnson. Can I do a legal call with you so I can give you her address?
Yeah, why don't you do that? Or if you give me a phone number, I can have my investigator reach out.
860-231.
Yep.
90.
Go ahead.
Can I do a legal call? So can you call me?
Yeah, I can do that.
Because I know this is live and stuff like that.
Yeah, no, you're right. That's why we never put that information on there. But let me find out if you're willing to do that. At least I have her name, and I can have my investigator reach out to you, to see if maybe a notarized letter or something saying, you're willing to turn over the phone to your grandmother.
Yes, thank you, sir.
All right, thank you. Thank you. No, I don't have anything else to add.
I'm gonna announce my findings, Mr. Mathis. Or on charge number 1, the condition of GPS, I am making a finding of probable cause based on the evidence presented in states exhibits E, F, J, and L. I'm making a finding of probable cause for charge number 2, behavioral management program based on the admission here and the hearing today, as well as the evidence presented in states exhibits B, F, and I. On charge number 3, I've identified this charge as separate parts, each part identified with the date as charged, and I'm making a partial finding for general no contact. So I'm making a finding of probable cause for the dates of 4/24, 4/27, 4/28, 4/29, 4/30, and 5/20, based on the evidence presented in states exhibits B, F, G, and K. I'm making a no finding of probable cause for the dates of 5/16, 5/18, 5/19, as the state failed to submit sufficient evidence in support of the charge. I've also identified charge 4, the halfway house placement, as separate parts, each part identified as a date as charged, and I'm also making a partial finding. So I'm making a no finding of probable cause for the date of 5/16/26, as the state failed to submit sufficient evidence in support of the charge. I'm making a finding on all the remaining dates based on the admission here during the hearing, as well as the evidence presented in states exhibits B, C, F, G, K, and N. Ms. Mathis, I am also finding that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you await that revocation hearing. So we'll let the records office know at the facility. We'll also let your officer know that you're going to move on to a revocation hearing. So what's going to happen is that's going to be scheduled in the next few weeks. At that hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. And if so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So it does conclude today's hearing. Like I said, we'll try to get you back here in the next few weeks. You have a question?
No, I don't have to. So Brian, I'll set up a legal call with you. I'll explain the next process to you. The dates and things where there's partial no findings, those won't be used against you again at the next hearing, okay? I'll set up a call with you, go everything with you, and I'll get that information for your grandmother to try to work on the phone, okay?
All right, thank you so much.
All right, for the same time.
This concludes the preliminary hearing for Brian Mathis and number 372016. All right, we'll see you in a few weeks, okay, Mr. Mathis?
All right, thank you guys. Have a wonderful
Thank
day.
you, counsel.